castes, but there is no corresponding inclusion in 342 of castes into tribes.
But I would submit, my lord, 341.
There are some tribes which resemble castes, but there are no castes which have been at least constitutionally been treated at par with tribes.
Tribes have gone both ways. My lord, that was the wisdom. That was the wisdom of casting 341, 342. I would respectfully submit. Lord, intercede, there is a difference of color in the simile that I give to your lordships, my lord. With utmost respect, my lord. Intercede 341, 342, therefore placed differently. 341, 342.
But how do you make the sequitur to your argument that according to you,
yes,
there is, though the birthmarks are different at the point of birth,
yes,
before their birth.
Now,
when does the homogeneity, so to speak,
yes,
come
Lord,
about
yes,
according to you?
So therefore, to start with, it cannot be denied on this side, in my most respectful submission, that there was heterogeneity. Cannot
according to you, when they are born,
yes,
in the list,
when they are being taken up,
there's a homogeneity.
And my lord, it will, in very nature of things, will happen. Because we are talking of races, castes, and groups, and tribes. There will be heterogeneity. We are talking of different, if we are talking of caste alone, there will be heterogeneity. We are talking of three different categories here, my lord.
Right, but we need not dwell on the heterogeneity because that you are accepting.
Yes.
When does the homogeneity come?
Yes, Lord. Yes, Lord. Homogeneity is that acceptance of the fact that the Constitution placed them. There was an inquiry, the 341-1 inquiry by the President. The state governments were consulted. They had a say, and then in the wisdom, put in a category. That is not to assume that there will be one-to-one similarity, my lord. There won't be. On the ground, there won't be a one-to-one similarity. Because the pickup point, so to say, is different. As I submitted, there is heterogeneity there. Has to be accepted to start with. But then, the sequitur, as your lordship put the query to me, is that they are put in the same entry, and then that entry is protected by the word deemed.
Twice over deemed. For the purposes of the Constitution, whenever you are talking of scheduled caste, please treat them, if you are talking of benefit to scheduled caste, you will treat them, they are deemed to be a class.
Could it be, I was just reflecting on it, that what's the reason for the use of the word deemed? There is no caste in India called a scheduled caste. Let's be very clear.
Yes.
There is no caste either in Punjab or Maharashtra or Tamil Nadu, which is called a scheduled caste. What the Constitution does is, it deems certain castes as scheduled castes. So it puts them into an artificial mold of what the Constitution terms as scheduled castes. That's why they are saying deemed to be a scheduled caste. The Constitution is not creating a new caste. The Constitution didn't want to create a new caste called scheduled caste by putting all these castes and saying, oh, all of you are one. That would have been contrary to the sociological profile. What the Constitution intended to do is that you are all different, disparate castes all over the country. For the purpose of this Constitution, we want to put you together in this one combination called the scheduled caste, and therefore the deeming. And the deeming is because by a deeming fiction of the Constitution, they become castes. But they are called the scheduled caste. Scheduled because they are put in a schedule. So the deeming is not for any other reason, but because they are deemed to become scheduled castes.
Yes, Lord.
There is otherwise no caste called a scheduled caste.
It couldn't have been, Lord, to further submit, my lord. It could not have been a caste. It is so debated in Thomas, so said so in Thomas in so many words. If your lordship will permit me, I'll show that.
Right, because even tribes become a caste. How can a tribe become a caste?
That's what it said.
How can a part of a group of a caste?
Yes.
For instance, you say that only this tribe in Gadchiroli, in Maharashtra, will be deemed to be a scheduled tribe. It can't be. Normally, if you are a tribe, irrespective of where you are found in the state, you are a scheduled tribe. The Constitution created this fiction.
Yes.
That the Constitution makers can say that if you are originating in this particular district of the state,
yes,
then you will be deemed to be a scheduled caste. So the reason for that deeming thing is really this, not to bring about a homogeneity, but to indicate that
No, homogeneity is another part of it, but I'll elaborate on that. Firstly,
But according to you, we are testing the argument. We are not concluded at all in our approach. But what you are saying is that once, though there was a pre-existing heterogeneity,
yes, my lord.
once they were all placed together in the schedule,
Yes.
they become a homogeneous grouping on
They
schedule.
become a
Would
class.
that,
This is
would that be a correct reading of your submission?
Lord, that's my respectful submission. Lord.
Okay.
Then they are placed. Lord, kindly also see those who are placed in 341 or 342, they are not being treated differently. In the presidential order itself, very significant, not in my most respectful submission. They are not being treated differently. Why? Because as a sequitur to what we just
What is the purpose of the presidential order?
identification, Lord.
You hit the nail on the head. So the purpose of the presidential order is confined to identification and identification alone.
Yes, Lord. And identification is complete in my most respectful submission in 341-42. There is no endeavor for anybody to enter in the temple of 341, 342.
Except the parliament.
Except the parliament. That is in the second part. I was wanting to say 341-1. I stand corrected, my lord. 341-1, there is no entry for
That
anybody
explains
else.
law is well settled that there can't be tinkering with the entries in 341 in the presidential order. You can't add even commas.
Yes.
Yeah.
Specific.
You can't go to synonymity.
Yes, my lord. As my lord's observing, lord, specifically said so in 341-2 that even the author, namely the president, will not vary by a subsequent notification.
Now we've understood
it was made-
understood your point on 341.
Yes, ma'am.
And I mean, rest assured that it's not a point which can be rejected out of hand. 5 of our colleagues have accepted that point in 2005. But now, having said that, how do you
request your
explain
office to accept-
its interplay with Article 16(4)?
Yes, Lord, I'll come to
So
permit
this first part is over. First submission is over.
No, Lord, no.
So your argument appears that there is only heterogeneousness at the point of entry.
Yes, Lord.
Once they enter that class,
Yes, Lord.
then it forms a homogeneous class.
Yes.
And no differential treatment is permissible amongst them.
Yes, Lord. And Lord, on ground, when we see the presidential order, the implementation thereof in the 1950 order, we find entries and entries and entries and no interstate difference between them to be treated alike. Lord, what it looks like is, if I can further take the point, Lord, that there was a threshold acceptance. It can't be, when I'm talking of races, castes and tribes and groups within and parts thereof, and even your lordships have said, it can be from a part of the country, a part of the state. That's the variegated variety of catchment points coming up. When such is the catchment point, it can't be that there have to be a 1-to-1 ratio. Otherwise, I have to make 341, 342 and so on. I will have to make maybe 120 entries. No, that was not the idea. Idea was have two groups to begin with. The third group has come later on. 341, 342A has come later on in 2018. Leaving that for the time being. Two groups were sought to be created and then divide them for the purposes of red and green, as I was wanting to give that simile, my lord. The threshold why I say so is that yes, they are heterogeneous, but they have these common traits in themselves. The basics ones, which I call the red ones. They are shades of red. Indeed, they are.
It has been emphasized very largely on the other side that heterogeneity, yes, it is.
But what do you mean that there were common traits?
that wisdom, I'm sorry.
Mr. Mansoori, what do you mean by common traits? Apart from the fact that all of them have faced varying degrees of discrimination in the past, what is a common trait?
Of different entries.
Not the
Discrimination is common.
Yes.
The fact that all of them face discrimination, social discrimination,
Yes.
is common.
Yes.
But can we say that other traits are common? I mean, what are those traits? Social backwardness,
Lord, there could have
economic backwardness, lack of resources, educational backwardness.
Yes.
The social indicators like infant mortality, maternal mortality, age of marriage of women. So typically earlier the age of marriage, it's always considered to be as societies become more progressive, the age of marriage of girls always increases.
So that's also regarded as very important. Then life expectancy. The more undeveloped community, the lower the life expectancy. So
What was your lordship's query? That what was that threshold, your lordship's query? Lord, I would respectfully submit, my lord, that backwardness alone, it may be social backwardness, it may be educational backwardness,
so according to there was one common trait, namely discrimination plus backwardness.
and that ought to have been, and that was, it has to be presumed, my lord. Why? Because that exercise is being done under 341(1). The president of the country is consulting individual states and union territories. The governors are being considered. They have the advantage of the local scenario. It is assisting the president, and he in consultation, and that elaborate consultation process has been elaborated by a lordship's judgment, my lord, in Bir Singh and all those judgments. Yes, my lord. It's an elaborate inquiry. The state has a full say in it. The state had a full say at that time. Yes, that is the stage. And that alone is the stage where the state comes in.
Right.
Is my respectful submission.
Fair enough.
They have a say. They are not a mute spectators. But what say, as I submitted, my lord, to begin with, the scheme of the constitution.
Now just tell us this. I've gone to your second. We have, I think, gone to the first and second bullet point under serial number 1. When
Yes,
you
my
say as amended in 2018,
Yes.
then you have to say that there was a proposal for insertion of 341(3) in 2000. That was following the Usha Mehra,
Yes, my lord,
Justice
yes.
Usha Mehra report.
Yes, my lord, yes. Yes. Lord, permit
Was
me.
that moved as was it a bill which was ever moved for amending, or it was just
It was a proposal, and the proposal said,
proposal at what stage?
it was a proposal right after the judgment in Chennai. Lord, just after right after Chennai, this
amendment was related to reservation promotion, no?
give me the language of it. Give me the language of it.
This in volumes for page.
Reservation and promotion is different.
Completely different. Completely.
Not for this matter. 241.
Lord, there is something.
See, yesterday when we were reading that report of Justice Usha Mehra,
Yes.
she at the end, the learned judge says that, it is proposed that we propose that Article 341(3) should be included.
Right? But when you say proposal, we just want to know, was
There is some assistance.
there any
There is-
bill, was it referred to a standing committee, did the bill lapse, or didn't come to that stage at all?
Well, I'll investigate that very frankly, but what information I have is that this was referred to the Justice Usha Mehra committee.
Other side may also just find out, a little bit, Mr. Farah sir, on what happened to that 341(3)
Certainly,
bill.
Mr.
Just a matter of historical importance.
Certainly, my lord. There's something that turns on an assistance in this regard, my lord. That what was that content and why and what was not accepted. What was suggested by Justice Usha Mehra's committee was an addition to 341(3), and the language is this: Parliament may by law provide for subcategorization or de-subcategorization of castes, race, tribes, or parts or groups within any caste, race, or specified in the notification issued under 1 or by a law made by the Parliament under Clause 2. It was suggested that there can be subcategorization. Not accepted. Right after Chennai.
It didn't go to the parliament at all, so what?
I'll be very clear on that, Milord, then make my submission on that. Milord, bullet point 2, Milord, if I can elaborate, in item 1, 342A. Milord, 342A is an 2018 endeavor, and 3 things are coming, Milord, in 2018. We are having to add 342A, 338B, and 366(26)(c), all in tandem with each other.
2018 amendment brought in.
Milord, 342A, the entirety of it.
Yes.
which has A,
Then
and my lord, it brought in 338B, which is a commission for the same purpose, SEBCs, and my lord, it brought in the definitional in 366, in 26C. It brought in these three things. My lord, what is the submission that follows is that they borrowed the 341, 342 model. Now we have the 1992 judgment Indira Sahni. We have all other judgments. And when I take your lordship to the select committee report, they are saying that Honorable Supreme Court in Indira Sahni wanted us to make a permanent commission. And that 340 commission is not the statutory constitutional commission. There is a commission, but it is the experiences of the SEVCs. That is not a statutory commission. That is not a constitutional commission. We want a constitutional commission for this purpose also, which will investigate and suggest the working on the ground. To put it very briefly, yes, it was a direction which is implemented now in 2018. Submission I am making with 342A is, my lord, that the constitutional march appears to be in the direction of 341-42. That is, have a presidential order. Please don't have this backward and more backward. Indira Sahni model was a model, backward, more backward in SEVCs. They are specifically saying, so please don't have that model. We please have a model of 342A for SEVCs. That is, President will consult the states and will come out with a list. And the variation will only be by the Parliament by law. But I wanted to further emphasize the implication of 341-2, as a sequitur to this scheme of the Constitution. But therefore, advisedly, in 341-2, expression is being used, include or exclude. It is in tandem with 341, my lord. Absolutely in tandem with 341. Because in the president has...
The parliament finds that a particular caste has reached, it has come to a mainstream. And parliament can exclude that from 341.
Yes, my lord. My lord, why the word vary was not included in 341-2? I ask myself this question, my lord. Only include or exclude. It's crucial to bring to your lordship's very kind notice, my lord. The expressions used in 341-2, akin to 342-2 and all these, the second part of the 341 chapters is include in or exclude from. Why? Because they are now deemed to be, this is a constitutional list. As my lord the Chief Justice put it, my lord, this is a list born out of the Constitution, never before. It couldn't have been a caste, my lord, because it would have been foul on 16.2. 16.2 specifically says, please don't discriminate on the caste. Tribe incidentally is not there in 16.2, but caste is there. Therefore, Thomas says very specifically, this is a class. This is a special class. I'm using the exact phraseology as used in Thomas. This is a class. This as a big run-up to discussions in 165 paragraph, the Honorable Court says that in Thomas, that this is a class, this is a special class. Para 165. Therefore, my lord, I would respectfully submit that very advisedly, it is in 2 that include or exclude. There can be no other shade of variation. State still has no role. It will be done by the Parliament. And Parliament by law will only include or exclude. Why? Because this is all homogeneous now and deemed to be homogeneous. You can't pierce that veil. That appears to be, my lord, in my most respectful submission, the use of the word deemed. That please don't pierce that.
Either include or exclude. And my lord, that fresh experience is not shut out. It is in 2. The fresh experience will be translated in this fashion. The state governments will have a fresh experience. They will send it to the commission. There is a commission now. There was always a commission 338. the likes of 338 for all the three categories?
There's a commission. Please send it to the commission. Commission is an expert body sitting there. It's a constitutional commission, a route created. That's the other submission. It is a route created, a constitutional route already suggested. And if suggested, my lord, any other route will be out, will be excluded by necessary implication. The route is that please, you have fresh experience. Yes, of course it can be a fresh experience. Nobody can say that fresh experience has no ventilation. Yes, state governments will send it to the commission. The commission's report, as per the language of 338, to be put before the parliament. Copy to be sent to the state legislature, to the state governments. To be sent to the president. The president will exercise 341(2) and will include or exclude. No vary there in 341(2) also. Even the president cannot vary. I would respectfully submit on the scheme of the constitution. And further indictment, further indication, if I may say so, in 341(2), that the author of 341(1) is injuncted that please don't vary it. Why? Because remembering the words of Dr. B.R. Ambedkar. Two things he said, not only one thing has been emphasized before your lordships. That famous paragraph which is often quoted. He said, political factors and disturbance in the list. He said two things, Lord. Please don't cause any disturbance. Disturbance is far more, my lord. Political factors is one, disturbance in the list. Goes hand in hand with no variations. State still doesn't have a role. I've completed 341, 342. State doesn't have a role except 341 initial part. You will be consulted. You, the state government, will be consulted. Your point of view will be taken. The call will be taken by the Honorable President. He will make a list.
But this last bullet point on 1 is just to give an illustration, my lord, that when we see, this is on the threshold, my lord. The summation is that when we see 41(6) for economically weaker sections, we find that a threshold has been prescribed, my lord. That somebody whose income is this much, is below this, is eligible. So therefore, there had to be a threshold catchment point. Otherwise, if I'm going to have a 1-to-1 ratio, I'll have to have 120 entries. It will be unworkable. I'm grouping them together and then I'm protecting it by a deeming fiction for the purposes of this constitution. But it can't be argued, as it was argued on the other side, that when I make 341, I am making that list and it has got nothing to do with reservation, because the earlier sections are talking of reservation. These category, the identification of 341 is identification for the purpose of this constitution. Wherever I need to talk of scheduled caste, scheduled tribes, I will be taking the identified category from 341. Not to say that 341 has nothing to do with a reservation. Why? Because reservation word is not used there. It is contained in a different chapter. It's contained in chapter 13. 16.4 is contained in part 2, in part 3. That takes me to summit. This EWS example is for that purpose. Two.
So what is your formulation on the EWS point?
The summation there is, my lord, that this is a threshold, yet another example in the constitution, that threshold prescription, which manifests itself. 341 is an exercise which was done by the president. We don't have the access to that. This is an exercise which is out and to be read. So 14(6), 14 bracket 6. I'm 14(6). 16.4. 16.4 is it?
Yeah, you said 14 by mistake, that's it.
No, it's
No, I'm sorry.
It's 16.6.
66.
Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any
Yes,
economically
yes,
weaker
please.
sections of settlement, other than the classes mentioned.
Yes, but the 16.6, nothing in this act to prevent the state from making any provision for reservation of appointments or posts in favor of economically weaker section of citizen other than the class, in addition to subject to a maximum of 10%. And here, my lord, there is a prescription of the economic threshold. Yes, there is a prescription of the economic threshold. That is to say, my lord, that is to say that in a classification, one-to-one relationship is difficult to achieve, and that was not the policy, that's not the scheme. Basic traits being found, grouped together. Nobody is questioning that. So to begin with, we did have heterogeneity, but then the constitution requires us, my lord, that this is a constitutional class now. This is not a caste, otherwise it would have been bad on the language of 16.2. No classification on the basis of caste. This is a class.
Now, for the purposes of Article 16.4,
Yes, my lord.
when the expression that is used is backward classes, it will include the SCBCs,
Yes, my lord. Yes.
it will include the SCs
Yes, my lord.
and the STs.
Yes.
So OBCs, SCs and STs.
Yes, my lord.
Now, for the purpose of Article 16.4, does the expression backward classes means the entirety of the scheduled caste as one conglomeration, or can it refer to individual entries in the presidential list also as a backward class?
Yes, my lord. My
Can we
submission.
deny the fact that an individual entry in the presidential order is also a backward class? If it is a backward class, then 16.4 would recognize the power of the state to make a special measure in relation to that particular individual entry as well.
Yes, my lord.
On the other hand, if we say that no,
As a whole.
the scheduled caste as a whole is a backward class,
Yes.
then that is not permissible.
Yes, my lord. I would say the later, my lord. I
Why?
respectful submission. And why, my lord? Throughout the constitution, your lordships would find only one expression coming when I take your lordships to 335, the efficiency. When I take your lordships to the other 46, when I cite 46, your lordships have seen it over the last 2 days repeatedly. Expression scheduled caste, scheduled tribe will occur as such. And even 16.4, kindly see, in
So
favor of.
interestingly, look at when we understand the interface between 16 and 341, we must recognize that in 16 itself, certain restrictions or certain measures can be imposed only by Parliament. So 16.3, state has no role. 16.3 is only Parliament. It says nothing in this article shall prevent Parliament from making
Any law.
any law.
Lordship.
16.4, on the other hand, says state,
Yes, ma'am.
which will include the union
Yes, ma'am.
as well as the state government.
Lordship, yes.
It refers to provision, not just law.
Lordship.
So when
Executive order can be
likewise
there.
16.4a state, 16.4b state,
Lordship. Yes, ma'am.
16.5 and 16.6,
Law by law.
16.5 law,
Law.
16.6 state.
State. Make any
Now,
provision.
therefore, the provision of 16, while 341 left the designation to Parliament, 16 by itself recognizes that the states will be implementing these special measures or making any provision as 16.4 says.
May I just, I'm sorry.
So the role of the states is directly then
Yes.
recognized by
They
16.4.
have a role, my lord, but what role is important, my lord? They have a role. Because that picture of 341 is incomplete without 16.4. 16.4 will have no meaning if 341 exercise is not there. That's how they're interrelated. So therefore, as my lord the Chief Justice asked me, what is 341, my lord? And my respectful response, identification process. But can the state take upon itself the identification process is the question I ask myself.
No, they can't do that.
It can't do
There's
it.
no question of identification.
They have no role in identification.
16.4 also
Yeah.
is only an enabling provision.
Lordship, yes.
Suppose if the state decides that it will not provide for reservation.
Before the vehicle moves forward,
Any of the matter. Yeah.
I'm sorry.
no necessity to provide reservation. That's the end of the matter.
End of the matter. Yes,
Therefore,
it can be done.
can you deny the ground realities that in a list, blacksmiths are there and scavengers are also there? Did they face the same degree of discrimination when they are brought in the list? Were they not untouchables among the untouchables? And therefore, if recognizing that, if the state decides to provide among that class a preferential treatment, would 341 come in that way?
Yes. Lord, my respectful submission is, my lord, that exercise, my lord, is an exercise which has been done in 341. And the shades of red and the shades of green have been identified.
No,
And-
it's exercise of identification of the classes or groups
Yes,
which suffered from discrimination.
have been identified.
But they don't go serial wise that higher the number in the list, the more discrimination, or lesser than if it is serial number 15,
Yes, my lord.
the least discrimination.
Yes,
So if the state,
yes,
it is for the state in order to achieve social and economic justice
yes.
to provide for reservation. And while doing that exercise, if it tries to find out that among that class who are the more disadvantaged and does some special provision for that, would it be barred by 341?
Yes, my lord. My respectful submission is that it would be barred by 341, and the reason
Then,
is
then,
this.
then it will perpetuate the inequality among those classes.
Yes, my lord. Yes, yes. But I'm aware. That's a submission, Lord. That's a submission on the other side, and that's your lordship's query to me, my lord. May I respectfully respond? My lord, this submission that comes from the other side is really questioning 341 exercise.
No, not at all.
So, because, after N.M. Thomas, it has been held that even if 16.4 was not there, still taking cue from Article 14 and 16.
16.1.
16.1.
Yes, my lord. It
the
could have been done.
state could have made reservations.
This is an equality measure.
Because the purpose is to remove inequality, so as to bring them equally.
Lordship, yes.
So, if your submission is to be accepted, take for example, a particular caste in Maharashtra. For last 75 years, if a particular caste has been occupying 75% or 80% of reservation, among that 13% reservation, and there are some castes which have a sizable representation, but they don't have even 1 or 2% reservation. So would it not amount to perpetuating inequality amongst that class which has been identified under 341?
Lord,
And if to remove that inequality, if the state decides to do some exercise under 16.4
Lordship, yes, Lord. That's a submission.
or 15.4,
Yes, Lord. The question that is being asked.
because
Yes,
341, if state exceed does not provide for reservation, it only provides for what would be scheduled caste.
Lordship, yes.
And then the reservation is provided under 16.4 or 46, provide that it shall be the duty of the state to make special provisions for advancement of scheduled caste, scheduled tribe and backward classes,
Lord, I would,
or for the purpose of 330.
Lord, I would respectfully submit, my lord.
Would it not hit at the very concept of Article 14?
Yes, Lord. I quite see that, my lord. I quite see that. May I make my respectful response to what comes from my lord's, my lord? I would submit, my lord, that this is the precise scheme of the Constitution. The scheme is that we will identify. And when identified, this submission that comes from the other side is actually questioning the scheme itself.
No, they don't question the scheme.
Lord,
They don't say that the identification is not correct. They say that among that identification,
Allow us.
there are
Yes.
certain classes which are more disadvantaged,
I quite see that.
and therefore allow us to bring equality in the real sense.
What is being put to me is not this, that having identified, say 39 in Punjab, we have 39, exactly 39 in Punjab. Why can't the state, what is being put to me is, why can't the state say that on experience we find that Mazhabi and Balmikis, they deserve some extra preference, 50%.
Special treatment among the special.
Among the special. Why can't they say, especially your lordship put it to me, in view of 16.4? Why? Because is it not an equality doctrine which is being followed by them? And if they are doing it, what is wrong? Where is the bar? That's as I understand the question. My respectful submission is this, Lord.
that this exercise of equation has been done and there is a mechanism to change it. And there is
Change it, you yourself argued
Yes, Lord.
there is no provision for variance. So either include or exclude.
Yes, Lord.
So if there is neither a necessity for inclusion
Yes.
nor a necessity for
To
exclusion,
And
but still there is a situation
yes,
That some classes among that class under 341
Yes,
have reached a particular level
yes,
and others are still at the bottom.
yes,
Would some tinkering in that
yes.
would not be permissible without touching the
list
special,
itself.
without touching the list or the special provisions to everyone who are included in that list?
Lord, kindly see, my Lord.
this exercise, Lord, therefore the word deemed comes, my Lord.
One more
Lord.
aspect you need to consider.
Lordship.
In 4,
Yes, my Lord.
it says any backward class.
Yes, my Lord.
That's the widest term used. There are 3 lists, 341, 342, 342A.
Lordship.
Can the state not identify another class as a backward class which is not included in 341, 42 and 42A?
It is being said so, my Lord. It is being said so that.
The state
this is
do it or
not-
not?
Lord, I can, I'm sorry, my Lord.
Can the state do it or not?
Lord,
Under 16(4).
it is being said and authoritatively said in Indrasani that 16(4), please don't read it as limiting the power.
Correct.
Because the opening words are, nothing in this article shall prevent the state from making any provision.
Significantly,
Yes.
16.4 doesn't use, it uses the expression backward class.
Yes.
It doesn't use the socially and educationally backward
Nothing.
classes.
Any backward
Any
class.
backward.
But
class.
at the same time,
Yes, my Lord.
it doesn't use the word caste or tribe.
Right.
Caste or tribe.
It has to be a class as a whole.
Yes, my
So,
Lord.
the state would have the powers to make reservation for the backward
Class.
class, not for the caste or tribe. So that fine distinction.
Class may not be
Because-
there in 341, 42, 42A.
Backward class which is not adequately represented.
Yes,
That has to be seen, not a particular caste.
yes. Otherwise, my Lord, my Lord, I'm very grateful, my Lord. Otherwise, that will be classification on the basis of
There
caste.
is a difference between caste and class.
Yes.
And see, all this would fall under SC, the backward class would include SC, ST and SCBC.
Lordship.
So that would be a class by
Class by
itself.
Yes.
It's not caste.
So class benefit is contemplated. Lordship, yes. Lordship. Lordship, yes. Benefit can accrue to a class as a whole. And Lord, kindly see the facts in Thomas. Lordship, yes. Yes.
Yes, yes. Lordship.
Tell us one thing.
Lordship.
Does Indrasani continue to, insofar as subcategorization is concerned?
We see backward and more backward.
Right.
Yes.
It permits that subcategorization for the
Indrasani did.
OBCs. We'll call them OBCs just as a.
Backward, more backward.
Now, Indrasani permits the subcategorization.
It does.
Is Indrasani overruled by the 2018 constitutional amendment?
Lord, it substantially, my Lord, when I take your lordships to the debate, it's very interesting, my Lord.
Indrasani continues to be good law. What does the 2018 amendment for Article 342A do?
It does this, my Lord.
See.
Sorry.
Under 341 and 342, in relation to the scheduled castes and scheduled tribes, exclusive power is vested in Parliament. Right?
Lordship.
What 342A does is that each 342A breaks it into two. It gives the exclusive power to Parliament in relation to the central list for the purposes of the central government.
Yes, my Lord, yes.
Right?
Yes.
342A1 refers to two things: the central list for the purpose of the central government.
Yes.
Right?
Yeah.
341 says for the purpose of the constitution. That's the other distinction. Now, 342A clause 3
State.
allows the states also.
To have an independent list,
for the
separate list.
For the purpose of the state.
States.
In fact, it says for the purpose of the state.
Yeah.
Every state or union territory may by law prepare and maintain for its own purpose.
Purposes.
So, it has bifurcated 341 and 342 into two
Yes.
by giving the states also the power to notify.
In regard to SEB,
Right.
yes.
Now, notwithstanding this, the logic of Indira Sani in regard to subcategorization into the backward and more backward is not taken away by the 2018 amendment which was made by Parliament. They could have done it, but they have not done it.
But kindly see,
Therefore, the logic of subcategorization in relation to the OBCs, which was brought about in Indira Sani, still continues to hold the field, notwithstanding the 2018 amendment.
Lord, kindly see.
Now, if that is so,
Yes.
would it not be appropriate to then to read that the power of subcategorization is also implicit in 16.4 itself?
Kindly see, my lord, 342A.
Subcategorization which 342A permits is not subcategorization, is actually, I'm using the wrong phrase.
Two lists.
It contemplates that there can be two lists.
Yes,
A central list for the purpose of the central government,
yes.
a
State list.
state list for the purpose of the
State.
government. So what is the distinction, as I said, between 341, 342 and 342A?
For the purpose of the
There's only
constitution.
one list,
Yes.
central list made by Parliament. Two, it is for the purpose of the entirety of the Constitution,
Lordship, yes.
right?
Yes.
Now, is there something intrinsically in 342A which would indicate that 342A recognizes the power of subcategorization, which 341 and 342 don't? There is, the hypothesis which I want to place before you is, there is nothing in 342A in regard to subcategorization, just as there is nothing in 341 and 342
Yes.
in regard to subcategorizations.
There's nothing.
Despite that, Indira Sani recognizes the power of subcategorization between the backward and the more backward. And 342A was not there when Indira Sani was pronounced.
Lordship.
So even before Indira Sani, even before 342A is brought on the Constitution by the 2018 amendment, our court reads the power of subcategorization. Where does it locate it? It locates it not in 341 and 342, but it locates it in 16.4. Therefore, the insertion of 342A does not alter that position.
Lord, I would respectfully.
If that did not alter the position, though Parliament could have while making the constitutional amendment, then why do we recognize it in relation to scheduled castes also?
Lord, I would
At
respect.
a conceptual level, Brother Gavai just said, for instance, otherwise what will happen is that the more advanced among the scheduled castes, they will grab all the benefits. In fact, Brother Gavai, you can tell that example of the MBBS.
Yes.
Maharashtra,
Yes.
till 1985, there was not a single candidate from Mehtar community who had got admission in MBBS. So for the first time in 1985, that too through court, he could get admission. Unfortunately, I was his lawyer.
Fortunately.
Fortunately.
Very fortunately.
There must be a super specialist.
So from that, so he didn't go to that. He became a doctor MBBS, he got a government job. He became a doctor, came and met me with a packet of sweets. So that was one of the most happiest moments for me, that it was a pro bono case. So 35 years after the constitution came into.
I may say so, fortunately, you were a judge. That's also fortunate.
For 35 years, and it is one of the most disadvantaged. Whether Vangi, they have to do the job of scavengers.
And
Not responding to, not making a.
now the position in at least in Maharashtra is that sometimes the merit list for MBBS of general category and the SC category is almost same. Because of Indira Sani, many of the scheduled caste persons get admitted in a general category because
They can compete with the general category candidates. Because Indira Sani says that those who are admitted in category, they can't be counted in scheduled caste category or scheduled tribe category.
I mean, it's not subcategorization, it is categorization for the purpose of definition.
Reservation.
Of SCBC in
Category.
Nuance.
putting categorization for the purposes of giving a beneficial treatment, so as to remove inequality.
Correct. So it's not subcategorization as well. Constitutionally, not per se subcategorization. You are saying you're giving the benefit, we rather give the benefit, this much of benefit to A, because B is getting all the benefit.
It is, and to bring equality among that class, covered by 341 or 340.
Qualities in categorization.
Your rejoinder, and Mr. Gurmeet Singh, you will have to deal with this point which Justice Bela Trivedi just made, that 16(4) contemplates that you take whatever makes special provision in regard to a backward class.
Yeah.
And suppose you say these two castes
That's the reason.
are going to get preferential allotment. Would that be doing violence to the language of 16(4)?
No, not at all, because
Yeah, just reflect on it. I mean, because we like a response. We'll just leave it at this. We just flag it, and you can deal with it in your rejoinder. But I might forget to ask, and then I'll realize at the end of it all that I can ask.
not done already.
Lord, may I make a respectful response, my Lord? Lord, there is in 16(4) vis-a-vis 342A, my Lord, the Chief Justice's question. I would respectfully submit 342A, which was not there, of course, in at the time of Indira Sahni. We have that now the list will be prepared, and there is a similar deeming provision in the opening of 342A.
342A is identical to 341 and 342.
Yes, my Lord.
Save and except for bifurcating the power. It says now the central government, there can be a central list for the purpose of the central government. There's a state list for the purpose of the state government.
Yes, my Lord. So, my Lord, I was drawing the point that how have we moved away? How have we moved away constitutionally from Indira Sahni? That was my Lord's question, my Lord.
Yes.
Lord, I would therefore wanted to read 342A, the first part of it, that unlike then, in 18 now, we have who will identify. We didn't have the benefit, obviously, of 342A in 1992, when Indira Sahni was decided. The later experience, what is brought about is the president may, with respect to any state, union, territory, or where it is a state, after consulting with the governor, by notification specify socially, educationally backward class of citizens for the purpose of this constitution, which shall be deemed to be socially, educationally backward class.
15(4). When 15(4) used the expression the state, 15(4) used the expression social and educationally backward class of citizens.
Yes.
Right? So backward class will also include socially and educationally backward class of citizens. But 15(4) made it implicit that when it said state, the center could identify it and the state could identify it. But because of the purpose of the central government special measures,
This difference, my Lord. Lord, the
scholarships by the union government and the Ministry of Human Resources Development, they can identify. States can do it for the state civil service, state scholarships. I'm just giving you an example. So what 338A now does is expressly recognize that, for the central government may do it for its purposes. To that extent, there is a little variation from 341 and 342.
No, there is indeed, because 3 is there, 342A3 is there, that is the variation. That variation is there. Lord, what further variation that has taken place and why may have moved
Could
away?
that be an indicator? I'm saying something in your favor. Could that be an indicator that insofar as the model for the SEBs is concerned, it's a little different from the model which the Constitution adopts for the SCs and STs?
Certainly, Lord.
We are still
there has to be a
we are
respectful
thinking
answer.
about the problem. That's something which we can put in your favor as actually.
Lord, that has to be respectful answer. Yes, Lord, there is a difference. Lord, I was wanting to make this further submission. That we have a model identical in 342A, where the identification was earlier being done by the government, Indira Sahni, of the SCBCs, the OBCs. But now that identification is identically being done as 341 by the Honorable President.
That is why we have moved away from that. And when it was left in the hands of the executive, it could be backward and more backward in Indira Sahni. But now we have an identical model of 341-42 to say that exercise will be similar. President will do it. He will consult the government, state governments, and he will prepare a list of SEBCs for that individual state. That's where we have moved away constitutionally, Lord, is my respectful submission.
All right. So now We have finished your item 1, I think your point 1.
Yes,
Now you can briefly deal with Thomas because
Yes, my lord.
so then you can
Lord,
proceed
permit me
ahead.
one submission, my lord. My lord Justice Gawai was pleased to ask me on 16.4 if I can respond to that, my lord.
Sure.
Permit me that, my lord. Indulgence. Lordships put a question to me. Identification has been done. There's no difficulty. They're not wanting to tinkering with that. Once they are wanting to get the benefit, if they don't prescribe under 16.4, you will get nothing. I get nothing. But if they prescribe in 16.4, then why can't they address the iniquities which are obtaining within the entries? This is the question as I understand, my lord. My lord's question. My lord, my respectful answer is this, my lord, that this entire exercise has been done in 341.
Entire exercise of
identification.
of
Lord, further.
social discrimination.
Yes, Lord.
But not the degree of discrimination.
Yes, Lord, yes.
We are again coming to square.
I have to make a further, Lord, this is a sequitur that I must submit further. This is the first part of
Because the ground realities are that among the untouchables are also
Yes.
some untouchables treat others in that list to be untouchables.
that disparity. How is it to be addressed, and why, if the state is giving the benefit under 16.4, why is it, where is the bar? Is my lord's question.
So to remove those disparities,
Yes, Lord.
if the state is doing some affirmative action,
Yes, Lord. Lord, my respectful submission is on the scheme of the constitution, that there is, if that inequality is there, then what is the scheme of the constitution, as I respectfully submit to your lordship's kind consideration. Lord, exercise of identification having been done in 341 and the imposition of the word deemed, they become a homogeneous class.
You made the point. You
They,
got
they
it.
become a homogeneous class.
once they are part of the class, then there can't be any
Got your
interest in
point.
discrimination.
Let me
among-
hear the other
Yes.
side now. In
And that's the constitutional mandate, as I respectfully submit, Lord.
Now,
Having said that,
now, let's move ahead. Now we must make some headway now because that I think we have also asked the question when we
I won't go point wise as I see it, my lord. I have
Alright.
covered, I've covered 2, 3, 4 more points as I am making a submission, my lord.
Thomas, because that's your item. You can just at
I
least
will not
maybe
permit
a minute or two because Thomas we have read, but you can make your point on Thomas.
I will not just 1 or 2 lines on Thomas and.
What do you want to say on Thomas?
Can I seek indulgence to make a submission on 16.4?
All right, go ahead, no problem. That is your point 4?
Yes, Lord, 60, yes, that's the last dot on that. On 16.4, Lord, I was wanting to answer the query.
Right, all right.
Lord. Why can't they address that question? Lord, that question has to be addressed. I can't be submitting that inequity cannot be addressed. It has to be addressed. But by whom?
We have a constitutional commission now, 338B, the likes of 338 for all the 3 categories, SC, ST, and even for SEBCs also we have now. Concentrating on scheduled caste, we have 338, a constitutional commission. So that experience will then go to the commission, will then go to the state governments, will have a feedback. That report will be placed before the parliament, will be placed before the state legislature, will be taken to the president, and he will include or exclude. Therefore, my lord, I submitted right in the forefront that the power very instructively, my lord, very, very importantly, in 341(2) is only include or exclude. Why? Because this is in tandem with 1. Deemed first to be all equal. Now you have fresh experience. I will exclude or include. It's not as if there is no ventilation for fresh.
That's what you are argued in the beginning. The power is only to either include or exclude, not to vary.
Yes, to vary. So there is room for fresh experience as it ought to be.
There is no middle path according to you.
I'm sorry, my lord.
There is no middle path according to you.
I would submit, my lord, and not on the annual of 16.4. 16.4 is not the route.
That we have already appreciated your submission.
Yes, my lord, because 16.4 is.
We have understood that submission.
Yes, my lord. I was just wanted to emphasize this. 16.4 is, I am the state government, I can prescribe, it's my prerogative, I may not prescribe. I may prescribe 15%, 16%, no more, and as a class. Because if I do it with regard to Valmiki or Mazhabi, I'm doing it on the basis of caste. Then I'm foul on 16.2.
I have to do it as a class. And this word, scheduled caste, scheduled tribe, is running throughout, hand in hand. 338, 335, 46, all these articles throughout. Yes, Lord. Lord Thomas, my Lord, my respectful submission. Lord, it was submitted that lumping will take place. This is being sought to be answered here in two at one go. That lumping will take place. All the benefits will come to one stand, and this is not a monolith block. The birthmark exists. Not the birthmarks do exist. They exist real as life. Why? Because those entries are there for anybody to read. Open the presidential order of 1950, those birthmarks are there. Those marks itself, originals are there. What birthmarks? They are live as anybody. But they stand eclipsed is my most respectful submission.
By the constitutional mandate, by the constitutional scheme. When the scheme says that they now, for the purpose of this constitution, this is my list. This is a constitutional list for the first time.
The birthmark of a race, part, caste, tribe, whatever, tribal, all those vanish. It stands eclipsed. So it is heterogeneous and homogeneous at the same time. Heterogeneous at the birth level, at the constitutional level, 341 level, it's eclipsed. It still remains. Anybody can see it. Only eclipsed. That's the aspect of homogeneous and heterogeneous there. And we'll kindly see just one or two observations. I can. Yeah, thank you. Lord, volume
So your
5.
theory that certain pre-existing traits are eclipsed by the constitution
Yes, Lord.
may to a certain extent hold good in the case of political representation. See Article 330, where 330 says that the seat shall be reserved in the House of the People for A, the scheduled castes, right? B, the scheduled tribes.
Yes.
So once it says they shall be reserved for the scheduled castes, the scheduled tribes, there cannot be any further bifurcation of the scheduled castes. It is reserved, and the proportion is indicated in clause 2. So there the constitution has provided a clear indicator that you can't, no state can say, well, I'll reserve only for a few of my castes because they are. For political representation, all the scheduled castes are bunched together as the scheduled caste, the scheduled tribes.
Yes, Lord. Lord, identically, Lord, kindly see 335.
The claims of the members of the scheduled caste and the scheduled tribe shall be taken into consideration. I would respectfully submit there is no room to say that the individual entries can be reached. It's being talked of as a class, members of that class. And kindly see the definitional, my lord. It throws light. 366. Apropos what my lord the Chief Justice is pleased to put to me.
366. 24. 366 bracket 24 thereof. The definition. Scheduled castes means, it's exhaustive, means such castes, races, parts or groups within such caste tribes as are deemed under 341 to be scheduled castes for the purpose of this constitution.
Correct.
We are talking of them as a whole, wherever we are, for the purposes of this constitution. Otherwise, Lord, the moment, I would respectfully submit, my Lord, the moment we start talking and we start classification on the basis of a entry or another entry, then we will be on the wrong side of 16.2.
Everywhere where scheduled caste or scheduled tribe word is used, starting from 330 and onwards.
Lordship.
But again, going back to 16.4, there is nothing like that. It's only backward class.
Lord, that,
Why not scheduled caste mentioned there?
Lord, why, Lord,
Not
very,
mentioned it.
Lord, it is explained,
Left
Lord.
it open.
Yes, Lord. Advisedly, Lord, that 15-4 came later. 15-4
Forget 15-4.
came later, 16-4 is earlier.
Is earlier.
Lord, 16-4 has been explained, and your lordships know that, Lord. That 16-4 includes not only scheduled caste, scheduled tribe, OBCs, and others. The power is not exhaustive. Para 803 of Indrasani. It's not exhaustive because the language is nothing shall prevent the state from. So there can be another class also.
Exactly.
But when we are talking of 16-4, we are again, my lord, in my most respectful submission, talking of it as a class. Backward class, scheduled caste, scheduled tribe.
Why do you scheduled caste, scheduled tribe, SC, BC, OBC, everyone is included in backward class.
Yes, Lord.
There could be others also.
Also.
So therefore, in identifying where reservation is inadequate representation, the state can decide which
Lord, but
class to be given how much benefit.
Lord, but this exercise is not that exercise. This exercise, which is impugned, section 4, bracket 5 of the Punjab Act,
Correct.
is an exercise to puncture the scheduled caste list.
In the scheduled castes, they found that these are backward classes, further classification. Therefore, they are extending that benefit to them.
Yes, Lord.
What is wrong?
Lord, the state has.
The idea is to get equality, to bring them up. So they are trying to bring them up.
Yes.
Others have already come up.
Yes.
So, all right, let others also come up.
Lord, there are two submissions that propose this, Lord. One, that
Why are you resisting that? It's in that class only.
And it is not as if you are deprived.
Yes.
You will still get it. And if they, fortunately, if they can make it, well and good. But if they can't make it, those street will again fall to you. Why?
Lord, kindly see the resistance is this. I can't see that.
No. It's like a general bogie of railway compartment.
Everybody wants to get in.
We have got in now, but we will not permit the others to come in
Lord,
once we are in.
Lord, kindly see the bogie example, how it translates on me. I am inside. Lord, kindly see the bogie example, how it translates on reality to me. I am inside, but for the 50%, I'll be excluded. I don't have. I'm there, I'm
Because
still not
the
there.
state has found on some analysis, some survey, some data I had collected, that this is where it has gone down and this is where it will come up.
No, there are
particular.
no, there are-
Therefore, they are trying to equal them.
Like
There are
in Tamil Nadu,
Yes.
they have found that those 7 castes which are grouped into one category, they are 35% or 40%.
No, 76.
Out of 76, but they hardly have 2% representation.
Lord,
So what
kindly
is wrong if some special provision is made for them?
Lord, kindly see the resistance is on two grounds. One, that the moment they pick Mazhabi and Balmiki, the classification is on the basis of caste.
Let me hear the other side. You
It's on
make
the
the
basis
point.
of caste,
Which is prohibited under,
found
which
from
is
16.
prohibited under 16(2).
16.2 and then not contemplated by 16.4. That's his contention.
Yes, Lord. That's one exception. Second exception to that is that this role they are assuming to themselves.
Which is exclusively with the parliament.
Is the
That we understood. So.
is the respectful submission.
But you know, in 16.4, though it says backward class and not caste, it says any backward class.
Any backward class.
So there can be a class within a class as well.
Lord, I would respectfully
That
submit.
class, only thing is it can't be an artificial class. States can't, in fact, we are going to ask them that question.
Yes.
States can't say, for my purposes, this is a class.
Yes.
They must demonstrate that it is a class on the basis of an objective criterion.
Yeah.
What is the objective criterion? Lack of representation in the services of the state.
And Lord, here in our case, that class is identified by the Constitution, 341, 342 exercise already done by the President. And that class identified, sealed by the Constitution, given a constitutional status, they want to puncture that, enter into that, translate their wisdom into that on the basis of caste, on the wrong side of 16.2, and say, we have come to this conclusion, Lord, that path is not available. Lord, therefore, I started with this. Is this the constitutional scheme? Do they have a role to play? Is the question which I asked myself.
What your argument is that
You can either give the benefit to the entirety of one class, namely the scheduled caste, or you can't give it at all. Don't give it at all. It's your decision not to give it to at all. But if you give it, you must give it to everybody together.
That's the
So
scheme.
your argument is that if the state finds that you have reached a sufficient stage now, then the state can exclude you.
No, my lord, state can't, my lord.
So
State-
the parliament can exclude you.
Parliament will exclude.
Parliament-
That's his
But,
They'll have a role
and,
there.
and then if the parliament finds that somebody is, some caste which is not included, the parliament has a power to include that caste in 341.
And will not kindly see the language, parts thereof, caste, race, tribes, parts thereof or groups within. So when it comes to exclusion, when the parliament will exercise the power, they have the benefit of this variegated pieces on the table, so to say. So they can say this part is excluded because of experience. The state will again have a role to play there. I must concede that. Why? Because they will have a role to feed the Constitutional Tribunal, 338B, Commission, the Constitutional Commission, expert body to monitor and to investigate. But kindly see that expression, my lord. It's very wide. The constitutional, the tribunal which is taking me to the next bullet point, my lord.
Mr. Swarup, the only problem is that, if you accept your argument, it will really come down to this. What is a sequitur? You always look at the sequitur.
Yes, my lord.
Sequitur is unless Parliament deletes either a particular caste in the entirety from Article 341 or a part of a group of that caste from 341, if that is not done, then the state is duty bound to give reservation benefits to the entirety of the Article 341 list in that state.
As it stands.
Even if the consequence would be the capture of benefits by the dominant among the scheduled castes,
I would submit, my lord.
isn't it?
Lord, therefore, I submitted on the first date.
So you must necessarily accept a consequence where benefits can be captured by a dominant or a set of dominant castes within the scheduled caste list as a consequence for which the constitution has no answer. The only answer is then go to parliament.
Lord, I would submit, my lord.
Really, that's the consequence. You have to then accept it.
I would respectfully respond this way, my lord. When we are looking at the constitutional scheme,
States have no power to then alter it. They are going to be the people who are going to be funding the posts. They are going to be sanctioning the posts. They are going to create the infrastructure, but you will have no choice of redirecting the channelization of benefits.
It's not that, my lord. The situation is they have a remedy, and this is the mandate of the constitution that please do it this way.
otherwise, not kindly see the other side of the picture.
Delete it from 341 in the
See
entirety.
the other side of the picture. Kindly see the other side of the
So
picture.
take a situation that there are other categories who are still at the bottom. So would excluding that category who has reached say a real as contemplated under Article 14 or 16(1).
I myself said so, my lord, that fresh experience has a ventilation, my lord. It can't be submitted on this side that fresh experience cannot be. Yes, my lord.
These are being perpetuated still, and they will have to follow the rigor of going to requesting the parliament to make changes. That's your submission.
That's what you have said. That, my lord, question is, my lord, my respectful response is this, my lord. The question really is who to do it.
Your answer again is only parliament can do it.
There's no debate on this side. There's no contest on this side that yes, if an inequitous situation is obtaining, it has to be redressed. There can't be a resistance to that. There is none. But who to do it?
There appears to be.
No. I said so. I'm making it clear that there's no resistance, that fresh experience has to come in. It's an evolving society. It's an evolving constitution. There's no difficulty on that. But who to do it as per the constitutional mandate is the question, my lord.
Now, Mr. Swarup, we've almost 1.5 hours now. What is the next major head so that we?
Yes, my lord.
Yes.
Lord, I wanted
Drift of your submission and.
Yes, my lord. I was on Thomas.
Thomas, now just tell us.
Yes, my lord. Volume 5, and yes, I'll just give that.
PDF 27.
Just give me a moment. Yes, Lord. Lord, PDF page 96, P96.
Simplify.
Lord, I must thank my lords, my lord, that I got acclimatized to working on this. Thanks exclusively to my lords.
You play with it, isn't it?
But for that cajole, I can speak for myself.
Which page you are referring to?
Yes, my lord. This is PDF, my lord, 97.
Page 23.
Volume 5, my lord. Volume 5.
Volume 5.
Volume 5, 165. To place 165, my lord. Para 165. My lords have that.
Yes. It's PDF page 96.
96.
96. I'm grateful, my lord.
In the instant case.
In the instant case, one of the main planks of the arguments put forward by Mr. Abdul Qadir, Learned Advocate General Kerala, this submission is going to be accepted that so far as scheduled caste, scheduled tribes are concerned, they've been given an exalted and a privileged status under the Constitution. And in the directive principles contained in Part 4, which a mandate of the state to consider their claims, it is necessary to consider this aspect of the matter in a little detail, because the main argument of Mr. Abdul Qadir has been that the scheduled caste, scheduled tribe are not did not fall at all within the mischief of clause 2 of Article 16, which prohibits discrimination on the ground of caste. The scheduled caste is not a caste as mentioned in 16.2. I'm inclined to agree with the argument advanced by the Learned Advocate General that the word caste appearing after scheduled is really a misnomer and has been used only for the purpose of identifying that particular class of citizens which has a special history of several years behind it. The scheduled castes and the scheduled tribes have been a special class. My respectful emphasis is a special class of citizens who have been so included and described as such, come to be identified as the most backward class of citizens. Therefore, this is again a deeming provision. They have been identified as the most backward. Lord, this is an ipse dixit of the state, Lord, today. That fresh experience, they have not been able to come up. They will place data before the commission. Empirical data. Today it's an ipse dixit on affidavit, and the data across the board vary. Private respondent A will say something.
We are not going to that question as to whether the data is sufficient or not.
Right, my lord.
That exercise is on into
By the appropriate stage.
After we decide the issue.
Lord,
The question is whether
this cloud is sought to be created that we are facing this iniquitous situation, and therefore we must readily come in and hasten to address that situation. Is a cloud being created? But is that cloud available? Because identified is a special class of citizens who have been so included and described as they come to be identified as the most backward class of citizens we have in our country. This is a run-up to reading 5 paragraphs earlier, my lord. I could give your lordships immediately, starting from 124, and this is 165. All these paragraphs, my lord, are devoted to this. Expressions, they are in they are the lowliest, they are the backward of the most backward, and then to culminate to say they are the most backward. In the face of this, for the state to say that we have identified this, Lord, I would say it's not available to them. They are arguing against N.M. Thomas when they say so. This is the most backward. 169. Kindly turn to one other paragraph, 169, a few paragraphs down. Thus, in view of these provisions, the members of
you read para 167 also.
165 minute?
167.
167, very 167 minute. a combined reading of 46 and clause 24, 25 of 366, that's a definitional, clearly shows that the members of the scheduled caste and the scheduled tribe must be presumed to be backward class of citizens, particularly when the constitution gives the example of scheduled caste and scheduled tribe as being the weaker sections of the society. Constitutionally, my lord, 46 says so. Your lordships have seen it, my lord. 46 says so.
What is also reproduced there, just in a paragraph above that.
Yes, my lord. The state shall promote special care, educational, economic interest, weaker section, in particular of the scheduled caste and scheduled tribe, and shall protect them from social injustice and all forms of exploitation. As a group, no segregation allowed. Whenever we talk of for the purposes of this constitution, look, these are the embargoes on them. What is being asked on the other side is, where is the bar? These are all bars. I have a separate heading of a bar. I'll place that also, my lord. Then 167, and when my learned friend wanted me to read 169. Thus, in view of these provisions, the members of the scheduled caste and scheduled tribe have been given a special status in the constitution, and they constitute a class by themselves. That being positioned, it follows that they do not fall within the purview of 16(2) of the constitution, which prohibits discrimination between the members of the same caste. If therefore members of the scheduled caste and scheduled tribes are not caste, then it is open to the state to make reasonable classification in order to advance or lift these classes so that they may be able to properly represent the services under the state. Undoubtedly, this can be done under 16(1) of the constitution. Yes, plus please do it as such for the entirety of it. Please don't bifurcate. Why? Because they are the lowliest and they form a class by themselves. Binding on all of us, my lord. N.M. Thomas says it, and they are arguing right in the contrary to this. Give me that solutions. What this was read. Andhra, I want in item 4, my lord. I am in the bullet point 3. Now I just need to touch one or two aspects, my lord. I think I have. Lord, in item 4 and the bullet point 3, the Andhra example is given that all these shades of ingenuity, if I may call it, with the utmost respect, will come up. What is that ingenuity in Andhra now? Punjab experience, you should have seen. 76 is my total entry.
Out of which 7 have been clubbed together, Arundhati.
As one.
Tamil Nadu is Tamil Nadu.
Tamil Nadu.
Tamil Nadu, actually, not Andhra.
Thank you.
That is,
Tamil
you'll have to
Nadu.
correct that. Huh?
Lord, my mistake. Tamil Nadu, Lord. Lord, why? I was asking myself this question, why 7? Because it can be argued that they are a class by themselves. If I come 1-to-1, Balmiki and Mazhabi, I may be criticized of 16(2). This is the ingenuity which will come up. And that is exactly what Dr. Ambedkar said no to. We don't want political factors to come in. We don't want any disturbance in the list. N number of situations and ingenuities will come in to factorize in that no, we are not including, excluding. But Lord, as it fell from my Lord the Chief Justice's first day, that this is virtual exclusion. This is my virtual exclusion.
Not an exclusion.
I'm sorry, Lord.
Among the reserve categories, only they have been given preference for 50% of the seats.
Yes, Lord.
So you can also compete for the 50%.
For the balance 50%.
No. But no. You can even compete if suppose a sufficient number of candidates it's a preferential allotment.
Yes.
So it's not a quota which is exclusively reserved for these 2 posts.
Yes.
To these communities. In Tamil Nadu. No, so it's only a preferential allotment.
In Punjab, first preference.
Sorry, Tamil Nadu it is there. I mean, in Punjab,
first preference.
It's first preference.
Yes. Lord, kindly see me, Lord. To the extent of the first
So
preference.
according to you, among that category,
yes,
the survival of the fittest has to be followed. So who are based among that category, irrespective of the relative degree of backwardness, they will get the post.
Lord, I'm.
What has been done in percentages has been
Where?
In Andhra, ABCD category, 7%, 1%, 1%. So, my lord, what we were getting earlier gets reduced, my lord. So that would be the factor, my lord. Apart from the other, this thing, my lord, whether the state has power or not, which in my submissions, they don't have. I wanted to distinguish, my lord, Chinnaya with the other matter. I mean, the submission is, my lord, if your lordships read, my lord, 15.4 and 16.4, 15 exclusively deals with SC, ST, my lord, which words your lordship will not find in 16. To that extent, my lord, once it is a class as a whole, it is a class of weaker sections or uneducated or lowly income, my lord. It will not say, my lord, that scheduled caste or scheduled tribe.
But 15.4 also does not exclusively deal with the SCs and STs.
Education backward class of
Primary-
citizens or for scheduled caste and scheduled tribes.
Right, my lord.
It says
15.4
as 15.4 also uses the expression socially and educationally backward class.
backward within them, my lord.
No. Or for the scheduled class and scheduled tribe.
Separately. Backward class, socially and educationally backward class of citizens or for the scheduled caste and scheduled tribes.
Right.
So 16.4 is actually broader than 15.4.
Broader, my lord.
Because 16.4 may include some backward classes which are not scheduled caste and scheduled tribes,
Right.
and strictly speaking cannot be regarded as socially and educationally backward classes of citizens.
In other words, it's being said, it's not exhaustive of the power.
That's all. So 16.4 may possibly be wider than.
Said so,
15.4.
my lord, 803 of
That's
Indra
right.
Thani. Said so already, that it is wider. And the opening language of 16.4, nothing in this article
Right.
shall prevent. Those words were.
And the words is not adequately represented in the service under the state.
Lord, this brings me, my lord, if I lordships permit me a few moments further.
You will also take into consideration the word that is not adequately represented in the service under the state.
Not there, that the exercise of 16.4 is not adequately represented, is a prerogative they exercise.
So therefore,
Yes,
amongst that class, if the state finds that
not
a
adequate.
class among that class
Is
is
not
not adequately represented,
Yes.
whether it will be depart from taking an affirmative action under 16.4 to remove those inequalities.
Lord, submission is 16.4 is indeed using that expression not adequately represented, but it is targeting what? The class as such.
According to you, when the state goes into underrepresentation, it must look into underrepresentation of the scheduled caste as a whole in that state, not that particular community within
If
the.
they do so, my lord, if they do so,
That will be
16.2, then they are doing so,
Contrary to
they will come out with an affirmative action by legislation or an executive order. If the state wants to address that situation, that we find that in this scheduled caste, we find that these people are eating away all the vacancies, they will have to come up with an affirmative action.
So to
If
put
they
it,
do so-
look at it like this, suppose the state finds that, say, a caste which has hitherto been doing predominantly the occupation of manual scavenging, right? They are underrepresented in the services of the state.
Yes,
The state can't take any action. Why? Because if as a whole, the scheduled castes are not underrepresented in the services of the state, then though there may be certain communities, I give you the classical example of those who are hitherto engaging in manual scavenging. State government then has no power because you have to look at the overall scheduled caste. You can look at the micro picture in relation to any of these castes.
And-
But according to you, a caste is not a class. That's the argument.
if they do so, my lord, then it will be on the basis of a caste, which will fall on 16.2. That will be a classification on the basis of caste. This is one reason. Second reason, they have no role to play. They have played their role. Lord, answering 16.4, my lord, en bloc state they find it unrepresented, then they will do so for the entire block, because any backward class of citizens, which will include SC, ST, OBCs and others, but as a class. It's not as if, as I submitted, the situation is remediless. Yes, there is a root, but state has no role, and they.
What is the root? According to you,
Yes, my lord.
you said that the words used is only add, include or exclude. You yourself argued that it is not permissible even to vary that.
It's certainly not. The root is this.
Therefore,
The root is this.
Again, I have to put it the same question. If it
Yes.
the state finds that
Yes.
A caste has reached up to 75%, but not 100%,
Yes.
and D caste is only at 10%.
Yes, my lord.
So either exclude A, though it has not reached 100%, and continue with the others. Would it not be injurious to you if the state does that? Or if the state recommends the parliament to do that, and the parliament does that?
Probably the root is 342A3. Kindly read it.
Yes, my lord. The third part of it, yes. The state list. The state list.
State by law,
Yes, lordship.
notwithstanding anything.
342(3). 342A3.
342A3.
But that is only for
SCBC.
SCBC.
Right.
Yes.
That class can be included in.
No, but SCBC.
Duty has been cast to maintain.
Give me that. Three. Give me that 3.
Well, yeah, body, yeah.
What do you have?
Notwithstanding anything contained.
A3. Yes.
Notwithstanding-
Notwithstanding anything contained in 1 and 2. I'm reading 3, 4. I'm sorry.
Yeah, 342A3.
Yeah. State is no power. Central list.
It may be different. See, my lord's question, Lord, and then I just immediately thereafter read 342A also. My lord, this is Gawai's question. They find that this is the data, some one caste has gone up. Lord,
They don't say one caste has gone up. They say that these 2 castes
have been left behind.
have no representation at all.
Lord, kindly see.
Far behind.
Lord, kindly see the iniquitous situation. There is no assertion on record from
We are
the
not
state.
going to we are not going to the sufficiency of the
That the
data.
High Court will test, or, yeah, because that
We
point
have
is
only to
not
see
been
whether
dealt.
they have the power or not.
Whether you know,
Just
they
wait.
had, whether they had collected data, whether they have data, what should be the threshold requirement, that we'll also lay down.
Yes.
Because it can't be that the states can just do everything at their whims and fancies.
Yes.
Obviously, the state is also duty bound because to act in accordance with the constitutional mandate, and they must have objective data, quantifiable data, as we have said. And that the High Court will test ultimately whether
Lord,
they
may I
have.
just
fulfilled
formulate
that
this
or
submission
not.
which I'm wanting to make. Mazhabi and Balmikis are taken up by this. Lord, is it to be accepted that none of these categories have advanced? There is an inherent
Again, you are
presumption.
going into the rationale of doing it.
That
Question
is
is
not
whether
the-
they have the
this is
power
not
or
the
not.
stage,
We are not
because-
going into the rationale.
Yes,
We are only.
We are testing the correctness of Chennai.
yes, my lord, yes, yes. Lord, I wanted to read 342A, my lord, and 3 thereof. And this is, of course, in the background of socially and educationally background. Yes, my lord. 3 thereof. nothing contained in clauses 1 and 2, every state or union territory may by law prepare, maintain for its own purpose a list of socially, educationally backward classes of entries to which may be different from the central list.
So it is presumed that SCs and STs are socially and educationally backward.
Yes.
They are the most backward class of the backward class. So that can also be done. This could be the route through which, if one finds that a particular caste is not being included, has not been included. So this could be included by way of 344A3. Probably.
Lord, each of these categories in 341, 42, 42A, they have a commission. Now we have a commission, a constitutional commission, which will advise and will send it, as I submitted, to the president. And there the fresh experience comes in. That's the route identified. They are trying to find a route in 16.4. 16.4 is only that you may give percentage of reservation. Yes, indeed so. It's a purpose. It's in part 3 that yes, nothing will prevent the state from making that provision. For that purpose.
Mr. Saru, actually the constitution has used 3 expressions: backward class, scheduled castes and scheduled tribes, and socially and educationally backward classes of citizens. Though backward class will include the socially and educationally backward classes of citizens and scheduled castes and scheduled tribes.
Yes, Lord.
Perhaps the scheduled castes and scheduled tribes as a grouping cannot fall within the SEBC. They are very distinct.
They are distinct, Lord.
Therefore, apropos my sister's question, when the state is exercising the power under 342A3, they can't exclude the SCs and STs or any part of the part thereof in exercise of the power under 342A3. Because 15.4 clearly specifies the scheduled castes and scheduled tribes as a distinct conglomeration from socially and educationally backward classes of citizens.
Yes.
16.4 makes that very clear, that it says for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or scheduled tribes.
Yes.
If the scheduled castes and scheduled tribes were deemed to be a part of SEBC, there was no need to refer to them specifically in 15.4. But 16.4 is much broader. Therefore, it just says backward class, which will include the socially and educationally backward, the scheduled castes, the scheduled tribes, so on and so forth.
Indeed, so.
And any other backward class as well.
And that expression, any, my lord, in 16.4, when they say any backward class of citizens, again talk of class, not any member of that class.
That is the point, really. That's the point which they have to meet, actually.
Lord, that takes me, my lord,
class.
if your lordships kindly permit, it is being said, that takes me to point 5, my lord, that Chinnaiya judgment is per incurium because it doesn't have a discussion on the interplay 341.1 and 16.4. That was argued, my lord.
Can you give us the paras of which in Chinnaiya, which according to they discuss it?
I've given it immediately there, my lord. 31 and 50. Right in the heading, my lord, the Chief Justice has. In the heading 5.
Yes. Oh, sorry, yes.
I'm sorry, my lord. It's there. In para 31 and 50.
So Chinnaiya does discuss the interrelationship.
Yes, my lord, it does. And it attributes the role, identification role, if I may summarize, if I paraphrase in my own way.
1 and 4.
Yes, my lord. In a moment, my lord. 796 of volume 5, my lord. Sorry. And at page, my lord, this is yes.
At page?
At 798, my lord. My mistake. 798 of volume 5, my lord. PDF page.
Let me just look at it quickly. Yes.
And this is the judgment, Justice Hegde's judgment in 31. What would be said is the content of 341 will be first considered. I'm sorry. My lord, 31 at PDF 798, my lord, of volume 5.
between placidum E and F.
Yes, my lord. And above that is the content of 341. And below that, as my lord's is pointing out, my lord, is the consideration of 16.4. Can I place that, my lord?
Yes.
On a detailed perusal of the Act, it is seen that Section 3 is the only substantive provision in the Act. Rest of the provisions are only procedural. Section 3 of the Act provides for creation of 4 groups of the caste enumerated in the presidential list of the state. After regrouping, it provides for proportionate allotment of reservation already made in favor of the scheduled caste among the 4 groups. Beyond that, the Act does not provide for anything else. Since the state has already allotted 15% of the total quota of the reservation available to the backward classes, for the backward classes to the scheduled caste, the question of allotting any reservation under this enactment to the backward classes does not arise. Therefore, it is clear that the purpose of the true intendment of the Act is only to first divide the castes in the presidential list of the scheduled caste into 4 groups and then divide 15% of the reservation allotted to the scheduled caste as a class among them. This is clear that the Act does not for the first time provide for reservation of scheduled caste, but only intends to redistribute the reservation already made by subclassifying the scheduled caste, which is otherwise held to be a class by itself. And then, my lord, well settled principle in law that reservation to a backward class is not a constitutional mandate. It is the prerogative of the state concerned if so desire, with the object of providing opportunity of advancement in the society to
classification, in the classification, there was a sub-classification.
Yes.
Not on the basis of caste, but on the basis of empirical data of not adequately being represented.
Yes.
Then how would it treat Article 16.2? And it is not a discrimination on the basis of a caste.
Lord, this is to submit. Lord, those were 4 groups made in Chennai case. The criticism on the other side was that 341 vis-a-vis 16.4 is has not been considered, and therefore per incurium. To that, my lord, what I wanted to submit was that the content of 341 and the content of the 16.4 has been considered by the Honorable Court in that bench in these 2 paragraphs.
Apropos what my brother said, 16.2 uses the expression only.
Only on the ground.
Right?
Yes.
Therefore, if the positive discrimination, if we can call it that way, in favor of these 2 communities is made not on the basis of caste alone, but on an objective factor, namely underrepresentation, which is contemplated by 16.4, then it may not offend against 16.2.
But kindly look how the language of the statute is cast. The 4(5) of the Punjab Act. These 2 categories are picked up, these 2 castes are picked up, Mazhabi and Balmikis, and a legislation for that. So the target group, so to say, is the caste, which according to our submission is foul on 16.2.
If they fail on underrepresentation, then it's a discrimination on the grounds of caste. But if they are right on underrepresentation, then it's not a discrimination on the basis of caste, because then it is based on objective criteria, namely the extent of the underrepresented.
There was no data when
We are not going to that question
may
whether
be
there
right
is data or
also,
not.
that High Court will deal with that.
Whether there was a data or not, or whether the data was sufficient or not.
that was saying when this was framed out, there was no such thing.
That, I mean, if you are right, the High Court will have to deal with that argument that you had no quantifiable data at all when you made that.
This data also in the, your lordship would kindly.
So sufficiency, insufficiency, existence, non-existence of data. The question is whether the state is powerless or not.
On the constitutional plane, I could submit when Thomas when Thomas lays down as a law that they are a class by themselves and that they are the lowliest. Lord, then for the state to say otherwise is by submission is not available to them.
According to the state, cannot go into the question of lowliest among the lowliest.
Lord, this is, they have reached the rock bottom. And also, Lord, kindly see, this is one side of the picture that fresh experience and there may be inequalities and we want to redress it. This is one part. There's another part. There may not be a political tinkering with this. And this is an all India feature now. We don't want a situation, the constitutional mandate, the constitutional
The
debate.
courts are there under Article 226. The courts can always examine whether the decision taken by them is on the basis of empirical data or not. It can always be found that as to whether the action proposed has a nexus with the object or not.
Lord, my submission is, Lord, why is this freezing exercise being done, if I may call it? Why is this freezing exercise being done? Why is this insulation exercise being done? To take away any aspect of political tinkering. The danger writ large, even at the time of framing, which your lordship, that passage has been seen. These are the two competing factors. Inequalities removal and the political tinkering. This has to be balanced. Therefore, the court is saying in Thomas that this is a class by itself. Now, how does the state enter into that class? In my respectful submission, they can't, without doing violation too. It's a class by itself. It's a special class, to use two exact expressions in 165 of Thomas. At the lowest rung. Now, where is the opportunity for the state to say, no, our experience is this, our legislation is this? No. Is my respectful submission, my lord.
And we will have to take into consideration the future possibility. Forget Punjab. Punjab doesn't make any reservation for scheduled tribe, a particular.
Yes, Lord.
Other states may make for a particular scheduled tribe,
Yes.
particular scheduled caste.
Yes.
That would be in exclusion of other scheduled castes and other tribes. So that may create a situation which may amount to discrimination amongst the members of the scheduled caste and scheduled tribes.
And scheduled caste, scheduled tribes, all taken to be the lowliest and to constitute a class. When held by Thomas, they want to pierce that. The entire effort is to pierce that. Lord Indra, Lord, I have one last of this first page in item 7. This Jayashree Patil, my lord, judgment said so, apropos my lord's question, that 342A brings in a new regime. 342A, those three articles which come in 2018, is being said in Jayashree. I could give the paragraph. The exact expression used is that it brings in a new regime. Vis-a-vis the Indrasani, it was compared. I could give that.
Yes.
Just give me a moment.
Yes. SC Patil is 1466.
Yes, Lord. Yes. At Milord PDF 1605, Milord, in paragraph 157, 158, particularly 158, volume 5, Milord, PDF 1605. These are the conclusions, Milord. I must first place that at 158, SCC page 140, Milord, 158 paragraph of SCC. The evolution from Indrasani, etc., all being noticed. 2018 noticed, select committee noticed, and then the culmination. This, can I place that note?
Yes.
At 158, this sequitur is only reason why changes are envisaged in the first place by the parliament, sitting in its constituent capacity, no less, which is to alter the entire regime by ensuring that the final say in the matter of identification of SCBCs would follow the same pattern as exists in relation to the most backward class of citizens, that is the SC and ST, through Article 338, 338A, 341, 342. Too much cannot be read into the expression centralist. That controversy your lordship has seen. That was redressed by bringing in centralist in 342A later on. That clarification came. And I could read one or two, my lord, conclusions in Patil, which are on the same page, my lord.
At 156, in paragraph 156, just above, my lord.
156.2, the use of the expression means interpreted to imply exhaustive definitional expression. that expression used in 366, the definitional one. And then if your lordships just come a little further down, my lord, 156.5, the expression of the use of expression for the purpose of this constitution also emphasizes the idea that for all purposes under article this, only the communities or classes deemed to be SEBCs under 342A would be treated as such in relation to the state. And then this conclusion. Kindly see the end of 156, my lord. Paragraph 156, the last few expressions. These expressions are omitted and an entirely new provision exclusively for the purpose of socially and educationally backward classes are inserted. That is the Commission 338B, which has independently consider all aspects relating to SEBCs in the manner identical to SC/STs.
So it's a constitutional commission which will consider the entire data.
If I can take a few moments on item 10 on the page next minute. But what we said is creamy layer, as if suggested creamy layer suggested is accepted norm in SC/ST. Lord, that is in the light of Nagaraja and that is in the light of Karnal, which were Jarnail Singh, which were 4A and 4B situations
of 16, promotional, not at the entry points.
So according to you, that's what, because as Mr. Gopal Shankaran said, so far no government, including the central government, have issued any office memorandum that a creamy layer would be applicable to scheduled caste, scheduled tribe also.
Yes, Lord. None at all to our notice as well, none at all. But what is being suggested is that there, by the root of creamy layer, the class of SCs is available for dissection.
Yes, exactly. It's a work in progress. क्या मतलब होता है उसका? उसका क्या? But the suggestion on the other side, or the submission on the other side, was as if to say that at one point the state volunteered to say work in progress. When creamy layer was posed by the Honorable Court, the state government volunteered work in progress. That's the exact response, my lord. But when creamy layer is being suggested, what is being suggested is that when we can enter into the list, when we can bifurcate the list on the threshold of creamy layer, why can't it be done? That means it's pierceable. That means it is subdivisionable. That is being suggested, my lord. And in that aid, Indrasani, Nagaraja, Ashok Kumar and Jarnail Singh are being cited. What I would submit is, my lord, Indrasani specifically said when it was permitting classification backward and more backward in paragraphs after paragraphs that we are not talking of scheduled caste and scheduled tribes. Your lordships have seen that paragraphs. That's one. Nagaraja is a promotional case. 16(4)(a), 4(b) for scheduled caste, scheduled tribes. So not at level 1, at level 2. We are at level 1 situation. So therefore, very different to talk of Nagaraja, very different to talk of Jarnail. Ashok Kumar Thakur, again Constitution Bench judgment, which is interspaced between the two, between the last two in item 10 of mine, between Nagaraja and Jarnail, Ashok Kumar Thakur comes, which is the validity of 15(5). Can make special provision for admission to educational institutions. The state can. So entry point, there they say no creamy layer. That's the correct position according to us.
The persons from scheduled caste who are now in a much advantageous situation, they should also continue to get the benefits of scheduled caste.
But those who are, my lord,
A
those
scheduled
who are
caste person,
your lordship say they will continue to get that benefit.
you are saying that no creamy layer. So a scheduled caste persons whose child takes education in say Shri Ram school or Sanskriti, and a person residing in some small village taking education in a Gram Panchayat school, he will compete with the son of a man who is taking education in the best of the schools in Delhi. This is what is meant by Article 14.
Lord, there has to be, Lord, I myself said there has to be a redressal if such situation comes. The route is there, but who is to address that situation is the question, Lord. Is the state to enter into it on the anvil of 16(4)?
So whether in last 75 years, whether a same family should get benefit of reservation on 4 occasions, 4 generations.
No, the answer emphatically has to be no, my lord.
And the persons residing in the villages to perpetuate to live in those situations.
Perhaps before even.
So that is not a question before us.
Yes, my lord, yes, indeed.
But the question your lordship has asked, that has been answered already. That's why the reservation was given. Only it was objective.
What else, Mr. Swarup? Anything now?
Lord, I'll just on the last two, Lord, on the last 2 points, if your lordships kindly permit, Lord, very, very briefly. Lord, what was argued yesterday in the second half later session was vertical and horizontal reservation. Lord, this doesn't qualify for intersectional. This is not intersectional reservation at all. It is not. This is item 12, my lord, in bullet point number 1. This is subvertical reservation. Because your lordships know, my lord, this is being dealt with in, if at all an authority was required, in para 812 of Indrasani, that horizontal and vertical, how do they work? And when do we have horizontal? That the horizontal position he can occupy in any of the verticals. Now here the Mazhabi and the Valmikis are staking claim only against one vertical, that is the scheduled caste. So there is no question of intersectional here. A solution being found that intersectional can be considered in this case. But I would respectfully submit no, my lord. This is subvertical. And that takes me to the last 2, my lord. Where is the bar? It was repeatedly asked on the other side. Lord, my answers are these, my lord, these 4 answers. The bar is 16(2). Where is the bar to state and taking into this endeavor? The bar is 16(2). You are identifying on the basis of caste.
But 16(2) says only on the basis.
Lord, kindly see the target. Lord, kindly see the target group.
And you know, there is of course,
Ah.
following Nargesh Mirza and that line of cases, I have also dealt with it in my judgment in Sabrimala. 16:2 at one stage, for instance, suppose you discriminate against women, right? For instance, you say that a married woman will not be entitled to continue as an air hostess.
Yes.
The argument was that this is not a violation of 16:2 because we are not discrimination only on the grounds of gender, but we are discriminating on the grounds of gender plus. Now, our court is now increasingly, after Nargesh Mirza of 83, our court has increasingly said that you can't get around that only phrase in Article 16:2 by adopting some other prohibited ground of discrimination and then say that, oh no, I'm not discriminating against you only because you are a woman. I'm discriminating against you because you are a woman and you have got married. That is inconceivable.
Yes.
But here, it's not just a discrimination only on the basis of caste. It's on the basis of a factor which is recognized by the Constitution itself in 16:4. Right? Because 16:4 expressly speaks of underrepresentation. So then it is not discrimination only on the grounds of caste under 16:2.
Gotcha. Lord, then I respectfully submit in the second bullet point, the bar is to be inferred from 341(2) that a route is provided. So all other routes are excluded. As I submitted, Willard.
Right.
And then the bar is that scheduled caste as a
That
whole
you have-
have been accepted as a class, which I
That you have
submitted.
already made.
And then the bar in the last bullet point in 338 that there is a route of the commission, a committee, etc. Now kindly see, Lord, these paragraphs I have mentioned in Devinder.
That's the referring order, right?
Yes, Lord, these 4 or 5 paragraphs.
We look at them. What are you trying?
Submission is this, Lord. A reading of these paragraphs, Lord, is this. State cannot be denuded of its power. State has to run to the aid and to ameliorate the situation. Lord, these are answers in generality with utmost respect. These are not constitutional answers to upset Chinaiya or to meet the reasoning and the findings of Thomas. These are the spate of reasonings running into these 5 paragraphs. That of course the state must have the power to do this. It is not as if there is no ventilation to the grievance. Yes, there is, but there is a route. There is a person identified who will do it as per the constitutional scheme. All these paragraphs run in that tenure. That's the respectful submission.
Thank
Very
you,
grateful,
Mr.
Lord.
Thank you, Mr. Rup.
And I far exceeded, Lord, your lordship's time.
No, but you are opening.
My apologies for that.
No, you are opening the arguments for your side. So thank you, Mr. Saru.
May it please, my lord.
Yes.
My lords,
Yes.
much of the ground has been already covered by I won't take much time, which I have already told. I will only submit regard to the, my lord, one thing. The questions framed by that. The first question was whether the provisions of the contained in section 4, subclass 5 of the Punjab Scheduled Act, Backward Classes Act are constitutionally valid, or whether the state has a legislative competence to enact the provisions contained in section 4, subclass 5 of the Act, whether the decision in E.V. Chinaiya versus State of Andhra Pradesh, I reported in 2005, volume 1, SCC 397 required to be revisited. The number 3, my lord, I will address first. Your lordship may see whether yes, sir. My lord, I have already, these submissions have been submitted by my learned friend, Mr. I'll be following that. And that is at volume 2, page 19. And the relevant which would be at page 23. Heading which has been given already there.
You are referring to Mr. Hege's submissions.
These were submissions, my lord, before the 5 judges, and I have
But
the advantage of.
Only 1 second, Mr. Agar. Mr. Sarup, which is what is the cross reference to your original submissions? Because you gave us 2E, we read that 2-page note. But where are your original submissions, the more comprehensive submissions? You can just give us so that, well, in our notes, we don't miss it. You can, before we rise, you can tell us.
It is on page 76, page PDF, volume 2.
Volume 2,
Page 76 PDF.
we got it, Mr. 76 to 91. Volume 2.
But I also had the answer to Usha Mehra, if your lordship want at this stage.
Mr. Sagar, you so you are.
Yes, my lords, I was. Now, your lordship may refer to page 28 of my submissions and the para number 3, in which I have very categorically stated that the appellant sought to contend that the treason in E.V. Chennaiya does not follow the judgment of a larger bench of this honorable court. Indira Sahni versus Union of India.
We are referring to para 3.
Para 3, my lords.
Para 3 begins with the Punjab government by a circular.
No.
We are referring to Mr. Hegde's submission.
Page 20, internal page, sorry, page 28, internal page 10 of the submissions.
Internal page 10.
28, man. Volume 2.
Volume 2, Mr. Hegde's submissions begin at PDF page 19.
Yes, that is. Now you're not.
You are referring to your submissions or Mr. Hegde's submissions?
It is Hegde's submissions, my lord, I have said so. It has already been submitted by Mr. Hegde. So I am addressing all
The
those very submissions.
Punjab government by a circular, right?
Yes,
All right, that's PDF page 21 in volume 2.
yes.
This one, sir.
Now, my lords, I may have page 28. But in this, may I start? May I? Page 28.
That's 3.
Yes,
The petitioners, appellants have sought to contest.
yes, my lord, this,
Yes,
I'm very sorry for little
No.
inconvenience, my lord. Does not follow. This, according to us, is not right. It is absolutely incorrect. And the judgment in Indira Sahni permitting sub-classifications was limited, as already stated by my learned friend, Sarup, that only other backward classes. I'll be referring, my lord, certain paragraphs. And further, it has in fact been, court has specifically stated that none of these observations will apply to scheduled caste and scheduled tribes. The relevant portions are here, my lord, 781. But I'll first address, my lords, have asked one question there. Your lordship may kindly refer to, your lordship may kindly refer, all right, to these very 81. 781, at the outset, we may state for the purpose of this discussion that we keep aside the scheduled tribes and scheduled caste, since they are admittedly included within the backward classes, except to remark that the backward classes contemplated by Article 16.4 do comprise some caste, for it cannot be denied the scheduled caste includes quite a few classes. Then, my lord, 788 is the next para. Further, if we keep in mind the context in which the Article 16 subclass 4 was enacted, it would be clear that the accent upon the social backwardness, it goes without saying that the in the Indian context, the social backwardness leads to educational backwardness, so both of them together lead to poverty, which in turn breeds and perpetuates the social and educational backwardness. They feed upon each other, constituting a vicious circle. It is a well-known fact that till independence of the administrative apparatus was manned almost exclusively by the members of upper caste, the Shudras, scheduled caste, scheduled tribes, and other similar backward class social grouping among the Muslim Christians, practically to entry into the administrative apparatus. It was this imbalance which was sought to be redressed by proving for reservation in favor of the backward classes, in the sense that Dr. Rajiv Dhawan may be right when he says that the object of Article 14.4 was empowerment of the backward classes. The idea was to enable them to share the state power. We accordingly of the opinion that backwardness contemplated under Article 16.4 is mainly a social backwardness, and it would not be correct to say that the backwardness under 16.4 should be both social and educational. The scheduled tribes and scheduled castes are without doubt a backward for the purposes of class. No one has suggested that they should satisfy the test of social net. While in this regard, then the further, my lord, the two paragraphs are more important. And if I may permit, I'll also state, though these have been many a times stated so, this support my submissions. We may now summarize our discussion under question number 3A. A caste will quite often be a social class in India. If it is a backward socially, it would be backward class for the purposes of 16.4. Among non-Hindus, there are several occupational groups, sects, and the denominations which for historical reasons are backward. They too represent the backward social collectivities for the purpose of Article 16.4. B. Neither the Constitution nor the law prescribes the procedure or the method for identification of backward class, nor it is possible or advisable for the court to lay down any such procedure or method. It must be left to the authority to be appointed to identify. It can adopt a method procedure it thinks convenient, so long as survey covers the entire populace. No objection can be taken to it. Identification of the backward classes can be certainly done with the reference to the caste along with others, groups, classes, sections of people. One can start the process with the caste wherever they are found, apply the criteria evolved determining the backwardness, and find out whether it satisfies the criteria. If does, what emerges is the backward class of citizen within the meaning and for the purposes of section 4. Similar process can be adopted by the case of other occupational groups, communities, classes, so as to cover the entire populace. The central idea and overall objective should be considered all available groups, sections, classes in society. Since the caste represent an existing identifiable social group class in passing the overwhelming majority of country's population, one can well be begin with it and then go to other groups. Section and classes C. It is not necessary for the class to be designated as backward class. It is situated similarly to the scheduled caste, scheduled tribes. D. Creamy layer can be and must be excluded. It is not correct to say the backward class contemplated by the Article 64 is limited to the socially and educationally backward classes referred in Article 15.4 and 340. It is much wider. The test or the requirement of social educational backward class cannot be applied to scheduled caste and scheduled tribe who undebatably fall within the expression of backward class citizen. The accent of the section Article 16.4 appears to be a social backwardness. Of course, social backwardness, education, and all are closely intertwined with the Indian concept. The classes contemplated in the article may be wider than those terms. My lord, in this, my respectful submission in this case is that which I'll be also addressing other paragraphs. India's Indira Sahni's case, very sorry, I say. Indira Sahni's case very categorically states and give a finding under what circumstances the concept of creamy layer has to be applied. When the ultimate finding was given that yes, the backward class can be subdivided. There are 7 paragraphs preceding this, my lord, in which the deep concern was shown about the rise of the creamy layer, the rise of those persons in the backward class, may it be any in the backward class, which at the cost of others, they say, they have risen so high. Even Krishna Iyer in his judgment, Rangachari has also shown that this very concern. So it was this concern which actually, I must say, that led to the court to reach on conclusion that it can be subdivided, the backward class can be subdivided. Now, before, my lord, which I'll be addressing post-lunch period, that whether these very circumstances warranted the state to subclass scheduled caste and scheduled tribes, with very utmost respect, whether there was any material to show that the other castes have risen very high. Or
Mr. Sagar, that, as we have been repeatedly saying, is a matter
I'm
which will
not-
go back to.
Yes, that, but I'm
so
just
that
giving
can't
preface.
they
It
decide
is a
here.
preface to that, not I'm going to address on that issue. Only on this, as whether in these very circumstances, they might have, it's a possibility that these two castes, Majbi Sikhs and Valmikis, have been suffering, and they are weakest among the weak. On this very issue, I'll be addressing this approach of the court. This very government was erroneous, absolutely, because other classes, if Mr. Sibbal has also, my lord, showed to your lordship 39 classes, in which many other, like for example, cobbler, like for example, snake charmer. And when I verified from that, my lord, these very castes have no houses in the village. They are asked to live in huts outside the village. They are on abject poverty. Some of them indulge in, your lordship may see, theft, etc., which may not be an issue here. The question here is their non-applicability of mind may be influenced by the political, whatever it is, but their approach was perfectly incorrect, which I would be.
We'll break for lunch and come back after.
Certainly, I am grateful, my.
I know the chief is done. What happened to that Justice Ulsa Mehta committee report?
Yes.
Private member, we learned which was lapsed. So I have that big.
Oh, I see.
I'll report now.
So, if you can just formulate your points.
First point, my lord, is this, which I have already stated. That it
Yes,
is
first point was
related
that
to
judgment in Indira Sahni was limited only to OBCs.
OBCs. And secondly, your lordship may kindly see, the ground which they have taken is that Indira Gandhi says the subdivision, sorry, which I have been using, my lord, my staff is correcting me, but I just forgot out of emotion. I'm very sorry. That's the. So
Elections are around the corner.
Anyway, a great lady is being remembered in this court.
The second is in the context of whether the
there is
creamy layer can be excluded. Indira Sahni spoke of the subdivision of backward class.
Yes, the basis of them, if it is allowed in subdivision is as per the Indira Sahni's case, so why not we can subdivide it? Our respectful submission in this case is citing these judgments is that it was not that they decided to subdivide, there was a reason.
In the context of creamy layer.
Creamy layer.
Point taken.
But
Third
whether
point.
you're not.
Third point now.
Third point.
Don't labor a point which you made. Yes, third
Yes.
point.
Now, I'm very grateful, my lord. Now, the third point which you am making that, my lord, who we are, I have not stated, I'm very sorry. Out of 39 castes, we are also scheduled caste. We are not backward class or educationally or socially backward. No, that is backward class we are. But actually we are scheduled caste. Out of 39 castes, 37 are our caste. And the reservation has been given to 2 castes. The difference between these ours and this is almost negligible, except this, that they are, these Valmikis are, as said to be, manually scavenging the dirt also, everything. But at the same time, who we are, I'm just going to, as Mr. Sibal has also shown the list, that kindly see the list who we are. Who are, I already saw snake charmer, a person who is cutting the crops, harvesting the crops, labor, cobblers, barbers. These are the persons which has been, your lordship may kindly refer to, very interesting to see that we are like them. We are not different. We have not risen much in the, out of us.
Sagar, you may have a valid point, but again, there we will have to leave it open to you to set this up as a ground before the High Court. I'll tell you why.
If there may be, your lordship is.
I'll tell you there may be some point to be deliberated on this on a more factual basis before the High Court, because they have picked up 2 castes, right? Now, suppose those who are excluded are in a position to show prima facie that, look, though we have been excluded, we rank on the same footing as the others who have been included and who have been given this preferential treatment within the SCs. Then the burden will shift on them,
of course,
to demonstrate what was it in regard to these 2 castes which the others do not possess. That is, you have excluded others
that can
be, according to them, similarly circumstanced. So they must then discharge the burden of showing that those who have been picked up are not similarly circumstanced.
It is just being submitted only for the reason that
that is the factual justification.
Yes, that's what I was submitting, but I have only submitted that petition, the appellant side referred to this very list. In this was not mentioned at all. Rather, it was said that Mochi and other etc. they are suffering for ages. I asked myself, Mochis are we, laborers are we. Your lordship, very interesting example. The example I give, my lord, which is, if I don't have the evidence, but it is correct that scavenger, your lordship, is collecting the dirt. It is being loaded to a truck. Truck driver is a backward class. Truck driver is a scheduled, another scheduled caste who is not Valmiki. Invariably, this is happening. Very interesting instances. A person who are in this class,
advanced class also.
My lord, your lordship may see, they may have the reason to say that they are weakest. Very well, they are weakest.
See, but therefore, what the point I'm trying to tell you is that I'm not saying that you don't have a point on this, but this is a point which has to be argued when the constitutional validity of the act.
I'm but just saying for the giving a preface.
You know, your wider point is that bifurcation is per se impermissible.
Yes.
Now, what you are saying is that, look, in the alternative, I'm putting it in the alternative, even if it is permissible, it can't be justified because those who have been excluded by this act from the preferential allotment are in all other respects similarly circumstanced, or at least some of them. May not be all the 37 are similarly circumstanced, but out of the 37, you can certainly establish before the High Court that we fulfill the same parameters of backwardness in relation to those two who have been included.
That's right, my lord. But I am just.
I'm saying something in your favor.
Yes, it seems, in first perception, it seems. I'm very grateful. But as a matter of fact, your lordship may see, let me also submit, there are other points also, that we have not excluded or included in that. We have given a preference. There is a marked difference between preference and reservation on one side, and preference and certainly an exclusion are also not very, your lordship may having a much difference.
So what is the submission?
One way of saying thing.
What is the submission?
Submission is this, that they do not have power, and it relates to exclusion. It literally relates.
It's already argued by Mr. Swaroop. The
Yes.
power for exclusion and inclusion solely rests with the parliament, and the state does not have that power.
That is in my favor. If state doesn't have that
That
power.
is already argued.
That is argued. I'm just supplementing. I will not give any details to that. Now I'm supposed to give because he has very elaborately dealt it. That's, I'm grateful to him.
That is the base
But
point. That is the
it's-
base point that you have.
Yes, that's the
So
supplement.
we'll say that the power for exclusion is not with the states. That is a formulation which
Yes,
Mr. Swaroop has substantially argued that point.
Please, my lord.
What is the next point now?
Yes, next point, my lord, I'll come. Please refer to the written submissions.
Just formulate.
Yes, it is whether the state has legislative competence to enact the provisions contained in section 4, subclass 5 of the Act.
Legislative competence.
Legislative competence, because we are being supported by E.V. Chinnaya's case that no, as a matter of fact,
Legislative, actually, Chinnaya has talked of legislative competence, but I think it jumbled up the issues. Legislative competence is a term which is applied to the division of powers not division of entries in list 1, list 2, and list
yes,
3.
then Chinnaya has.
Really speaking, the power either exists or it does not exist under Article 16(4).
Yes.
So Article 16(4) is not a matter of competence, it's a matter of constitutional authorization.
Yes, Chinnaya has, if
So,
your lordships may
I know that
recollect.
one para, they say that
Yes.
therefore it is not referable to entry 41 of list 2 or entry
Exactly,
25 of list.
the doctrine of pith and substance was applied there in that case also, and inter alia stated that actually that this very act is.
Competence they have. It will be very far-fetched to say that legislative competence is not there.
My lord,
Because entry 42 of list 2 says state public services.
Yes.
So they can enact any.
41,
the entire 41. The entirety of the gamut of state public services falls within the state legislative domain. Your point, however, is that while enacting a law under entry 41 of list 2, you cannot breach a substantive constitutional restriction.
Yes,
Because
I was coming to that, my lord. I was.
because all legislation,
It is my, if you.
all legislation is subject to part 3 of the constitution.
Then, my lord.
But a part 3 argument does not go to competence, but to
Then
constitution.
my lords may kindly refer to Chinnaya. There are certain, my lord, let me refer it. It was Chinnaya.
Questions were formulated. Use that phrase,
That it was used
Leave
by.
it at that. I mean, that's okay. There's a passing remark over there in that paragraph.
Let's, my lord, may examine Chinnaya. Chinnaya is.
All right. Why don't you do this? You formulate the point. Let's have your formulation first.
Yes. Whether,
Not whether. Whether would be an issue. You are now submitting.
it's all right then, because in the written submission, it is written, I have just copied.
That's the problem. You are borrowed Mr. Hegde's arguments, and therefore he has not properly framed it, and you have to read it. It's better, he should be arguing from your
So tell us, why don't
list
you
rather than.
formulate your submission?
Yes, my lords may see. My now submission is the state lacks, my lords, that legislative competence to enact the provision contained in section 4, subclass 5 of the Act.
1 second.
That is my submission is at page 33.
Your submission or Mr. Hegde's submission?
My lord may take me as a Hegde.
impersonation.
Yes, if Indira Sahni can become Indira Gandhi.
Why not Mr. Why not
As
Mr.
it
Sagar
is.
come, Sagar become Mr.
What
Then
is that?
take it as.
What is that?
Then after Mr. Swarup's argument, the matter should have been over.
It should
They
have
are
been.
so homogeneous.
It should have been.
All right.
Sagar is relying on a deeming provision.
Obviously,
Now,
thank
you are saying that the state lacks legislative competence to enact section 4 bracket 5 of the Act.
Please kindly refer
Now,
to
tell
page.
us which is the entry under which it will fall.
It will fall under, my submission would be, it neither falls under 41, nor falls under nor falls under 25 of the, this schedule 2, second. Concurrent list. If your lordships may kindly refer to page 33.
Why?
Because as per Chenaiya,
No, don't forget Chinaya, because Chinaya is what we are reconsidering now.
yes.
Right? For us, Chinaya is not of a higher court, in which case we are bound.
No,
We are now
that is, I'm,
you have to argue it dehors Chinaya.
no, my lord, with respect, if I am saying Chenaiya is correct, then I have to justify his.
Right, but that we
Chenaiya
can't
is-
shut our minds, right? We are a bench of 7. We have to
Of
now
course,
deal with it.
Of course, my lord.
It's like arguing a first appeal. In a first appeal, before a high court, you never show that this is the judgment, my lords. You start with the plaint, you start with the issues, you start with the written statement, you look at the evidence. First appeal is judgment, the trial court judgment is shown at the end.
Yes.
So it's the
your
same thing in constitutional matters. You have to argue it on first principle before us. Otherwise, we
Yes,
get impatient.
your lordship may.
As we
My
are
lord,
tending to.
my lords may refer it. My lord, my respectful submission, if your lordship may kindly refer to page 33. Section 5 of the Act very clearly says that 50% of the vacancies of the quota reserved for scheduled caste in direct recruitment shall be offered to the Balmikis and must be Sikhs, if available, at first preference among the scheduled caste. The respondent submits that this amount to an
So, Sagar, rather than reading the submissions, why don't you form your
Just explain it to us, because why do you say it doesn't fall under entry 41? We got the point that this is unconstitutional because it breaches Article 16(4). That's a valid point.
I am very grateful, my
Valid
lord.
in the sense
Now I
not-
will explain.
Not
Now I
valid in
will-
approach, not valid in
If,
necessary
that's why,
conclusion.
if we kindly refer to the Act says, Act has made a subdivision on the basis of the caste. On the basis of the caste, it has been done, not in order to achieve any other objective like, for example, for appointment, furtherance of your lordship may see appointments or a reservation, giving a
Can we
reservation.
suggest one thing? Can we suggest one thing? You've got your point. But it brings us back to your central point that this is a reservation on the basis of caste.
Yes.
Now, assuming you're right, we proceed for a moment to test your argument on that you are entirely right. So then, which is the constitutional violation? The violation is of 16(4), not of legislative competence.
Your lordship.
Unless you say that the field is exclusively reserved for Parliament under entry 97. That will not say.
That would really, because here your lordship is reconsidering Chenaiya. I am repeatedly, my lords, may saying one thing only, that the finding given in the Chenaiya in this regard is perfect. Your lordship is going to consider whether it is wrong or right, or it is as per law. But
Right,
that
but we are
is why,
trying to understand why, according to you, is it lacking in legislative competence?
that's why it
Just
was,
explain, because, see, legislative competence.
no more legislative competence otherwise is there. Of course.
That's
Yes,
the point which I'm trying
otherwise
to
is
tell.
there if I say, but it is absolutely a violation of the constitutional mandate under your lordship may Article 341. That's why on the next
So,
page,
Sagar, that has been amply argued by Mr.
that I
Swarup
understand.
for last
I
few
will
hours.
not be elaborating at all like Mr. Swarup.
Say-
I'll be just giving.
It doesn't mean that if the same thing is said 10 times,
No,
it will have a more value.
all right, then
And
my
Mr.
lord,
Sagar, Mr.
my lord
Sagar,
may consider
Back
this.
to the drawing block. The validity of a constitutional provision can be challenged on 3 counts.
Yes, my lord.
One, that
Legislative
the legislature which enacts the law does not have competence to enact
Yes.
it. 2, it is in violation of Part 3.
Yes.
3, it is in violation
any
of
other
any other
constitutional
constitutional substantive constitutional provision. Now, what we are trying to tell you is that you can't mix the first with the second.
That your lordship may, I confine only myself to the, it is the.
That's right.
I'm only
All right,
confining
now what is the
myself,
next
though I
point?
had elaborate submissions, which
right,
my,
we'll consider.
my lords have said this has already been dealt by my learned friend. So therefore, my lord,
What is the next point now, Mr. Sagar?
Next point.
Your submissions will read, your submission as well as Mr. Hegde's submission. Both will read. So your submissions are prior to Mr. Hegde's submission.
Now, what is the next point, Mr. Sagar?
Point is the now my lord remains the only one.
Yes.
That is again I'm saying. Then now let me refer to the E.V. Chinnaya's case, then I'll close my submissions.
All right. Can you formulate what part of Chinnaya that you are adopting as your argument?
Yes, I'll be,
So instead of reading Chinnaya,
yes.
what we would suggest is you can certainly say that I'm adopting the reasoning in Chinnaya as my own.
Yes.
So you just formulate that because that might appeal to us better because.
Your Lordship, Mr. I very respectfully submit that the finding given by the Chinnaya in his judgments regarding this very. Yes, if Your Lordship may see, that the subdivision made by the state is absolutely and the violation of the Article 341 for the simple reason
Yes.
that it cannot be tinkered with at all to the presidential list of the scheduled caste and
This point you have made. Thank you. Thank you, Mr. Sagar. Yes, Mr. Hegde.
I'm not allowed to read Chinnaya. No, my lord, there is one.
Not after it has been read by 7 or 8
No, my lord, in this case, there is
What
one
happens, Mr.
paragraph.
Sagar, when you drive, if you have driven a long distance, when you drive, there's something called white line fever. You see constantly that white line on the middle of the road. For judges, it's black line fever. You're constantly seeing the printed word. So that's why you want to be.
What your lordship has read it many a times, no doubt about it. But as a matter of fact, if your lordship may see, I may suggest something, it might come. You never know it. Law is always, my lord, have a many ramifications, many branches.
If you formulate
Allow me
even
to-
now, in a minute, if you formulate what in Chinnaya you are trying to emphasize, we'll take it. We have no difficulty.
Yes, I will, with reference to that, I'll refer only 2-3
Mr.
paragraphs.
Sagar, minds are open until the last word in a matter is said. But as the argument progresses, it has to be more and more chiseled and distilled then.
It's all right then.
Thank you, Mr. Sagar. Yes. Yeah. Will you formulate your point now?
Yes, sir. My lord, I have 6 submissions, my lord. With respect, my lord,
Dr. John, can we have a formulation? What is the first point?
first point is, my lord, whether the decision in E.V. Chinnaya is correctly decided or not. My contention is that it is correctly decided, my lord. And to supplement this, my lord, I have supplementary issues, my lord. Whether there could be any political factors in the identification or in the case of provision or not, my lord. To my understanding, my lord, there cannot be any political factor, my lord. And then the third is, my lord, whether the scheduled caste are caste or classes, my lord. So this is well settled, even in Indra Sani, my lord, that scheduled caste are not caste, they are classes, my lord. And the class is always a homogeneous class. You cannot bifurcate it. If you are bifurcating it, then it will be an arbitrary exercise, and it will hit by the provisions of Article 14, my lord.
Just one second. And bifurcation will violate Article 14. Yes. Right. Then 3.
Whether the list of scheduled castes prepared by the president in terms of Article 341 of the Constitution of India could be tinkered by the state by enacting a provision under Article 15 and 16 of the Constitution or not, my lord. That is the.
We will just reframe your proposition that the state cannot tinker.
Yes, my lord.
With the list of scheduled castes.
Because once the entry, as Mr. Sarup
Notified by the president, notified by the president.
The caste, once it is added to entry, my lord. The entry is added to the list, my lord.
State cannot.
Thereafter, state, even the center cannot do it, only parliament can do it, my lord.
You are absolutely correct on
Yes,
that.
ma'am.
Now, what's the next point?
Then next point is, my lord, what is the connecting thread of all these castes, my lord? That is very important, my lord. Nobody has answered that. The connecting thread is, my lord, untouchability. For backward classes, the social and backwardness is the only criteria.
1 second, just 1 second. The connecting thread, we'll say for the notified castes.
Yes, my lord.
Is
untouchability, my lord. And which is abolished by Article 17, my lord.
Say into brackets prohibited by Article 17. Right, then?
Then my last point is, my lord, that whether the caste-based reservation is permissible.
We'll say caste-based reservation is not permissible.
Yes, my lord. So, if yes, whether such action is contrary to state of Madras versus Champakam Durai Rajan, my lord.
Yes.
So, to make good this, my lord, I want to go to the Constituent Assembly debates, my lord, which is in volume 2B and pages 1 to 4.
2B page 1 page.
Page 1 to 4, my lord, and the first page it starts.
Go to it right away. Page 2. आगे जाइए थोड़ा सा. ये बगल मुझे एक अच्छा लगता है आगे तो.
The Constituent Assembly has debated Article 300A and 300B, my lord, on 17th of September 1949, my lord.
PDF page 4.
Volume 2. Volume 4, my lord. I'm sorry. I'm sorry, my lord.
Argument is, Mr. Chauhan.
I thought the earlier one, that is my submission, my lord, at 2B is my.
So page 2 contains the Constitutional Assembly of India debates.
It is there in the submission also, my lord.
Yes.
My lord, may come to page 2, my lord.
Yes.
The object after the articles, my lord, the object of these articles, this is Dr. Ambedkar's statement before the Constituent Assembly, my lord. The object of these two articles, as I stated, was to eliminate the necessity of burdening the Constitution with long list of scheduled caste and scheduled tribe. It is now proposed that the President...
Actually, see the last sentence, the object, that is the most important part.
Yes,
very celebrated statement of
yes,
Dr.
yes,
Ambedkar.
yes, ma'am.
The object is to eliminate any kind of political factor having a play in the matter of the disturbance in the schedule so published by the President. That's why you are saying that you can't tinker. Once it is notified, Dr. Ambedkar said you can't tinker with it, then it's only the power of parliament.
Yes, ma'am. Once the list is prepared, my lord, and the entry is added to the list, thereafter, whatever treatment is to be given.
Has to be by parliament.
No, my lord. Parliament can do it, that is different thing. But state has to treat every person who is forming part of that list similarly. If they are treating them differently, that will be unconstitutional, my lord.
Fair enough.
An arbitrary exercise, my lord.
Fair enough.
So, my lord, if we see Chinnaiya has cited, my lord, this.
Chinnaiya cites this speech of Dr. Ambedkar.
Yes, my lord.
We have seen that.
Yes, my lord. And in this Mandal, my lord, the meaning of class and caste was, then I come to the next point, my lord, whether they are class or caste, my lord.
Yes.
So, in para 49, my lord, of Mandal, my lord, this is volume.
Indra Sani.
This is volume 5, my lord. pages, my lord, 190 to 745, my lord. And this is at page 350, my lord.
PDF?
Yes, yes, my lord, 350.
Para?
This is para 49, my lord. And it is there in submission also, my lord.
No problem. We just quickly look at that.
Meaning of class and caste.
Para 49, my lord.
PDF 354.
39 is
SCC page number is 377, my lord. 350 is the bold page number, my lord. Meaning of class and caste. To identify the diversity of meaning of the word class and caste that constitute their inner complexity, to formulate the question
Go
about...
to the next para. Go to the next para.
Yes, madam.
Then they give the dictionary.
Then these are dictionary meanings, madam.
Go ahead, go ahead.
Corpus juris secundum.
Go further down.
Law dictionary. Now come.
Then, my lord, we come to page, this para 63, my lord. That is at page 353, my lord. Article 15, Article 15.4, 16.4 and Article 341 do not speak of caste, but only class. The learned counsel, particularly those appearing for anti-reservationists, have stressed that if the makers of the constitution had really intended to take caste or caste as conveying the meaning of socially and educationally backward class, they would have incorporated the said word as caste or caste, my lord. In Article 15.4 and Article 340, Clause 1, as socially and educationally backward caste or caste, my lord. This was suggested by Justice Pandian, that this should have been the frame of that provision, my lord.
Mr. Chair, Dr. Chauhan, go to para 64.
Yes, my lord. The word caste is not used in the constitution as indicative of any selection of people or community except in relation to scheduled caste, which is defined in Article 366, Clause 24. However, the word caste in Article 15.2, 16.2 and 29.2 does not include scheduled caste, but it refers to a caste within the ordinary meaning of caste, my lord. Then the word scheduled caste came into being only after notification of President under Article 341, as Mr. Swaroop has contended, my lord. It would be appropriate in this connection to recall the observation of Justice Fazal Ali, my lord. These Mr. Swaroop has read, my lord. Then Justice Matthews, I may read para 65, my lord. In his separate judgment in Thomas, expressed that it is by virtue of the notification of the President that scheduled caste came into being. Reference also may be made to the observation of Justice Krishna Iyer in Akhil Bharat Shoshit Karmachari Sangh vs. Union of India, where he has said criminological similarities are an illusory guide and we cannot go by verbal verisimilitude. It is very doubtful whether the expression caste will apply to scheduled caste. At any rate, scheduled castes are identified by their tribal denomination. A tribe cannot be equated with a caste. As stated earlier, there are sufficient indications in the Constitution to suggest that the scheduled castes are not mere
Dr.
caste.
Chauhan,
Yes,
just read para 82. I think, after citing all the cases, just see how they summarize their discussion. You can actually see para 81 first. Though there is tremendous...
PDF page 361.
So, there is a tremendous ambivalence in a host of judgments rendered by this court. Not even a single judgment has held that class has no relevance to caste at all whenever caste system is prevalent, my lord. To this, my lord, my respectful submission is this, my lord. For formulation of that list you can have a caste, my lord. And the caste is a class for the purpose of entering into that list, my lord. Once that class, that
I think
caste.
there is a little bit of a confusion here.
Yes, yes, madam.
What they are saying is not that a caste can never be a class.
Yes, ma'am.
What they are saying is, you can't treat a caste as a class unless it satisfies the parameters of social and economic backwardness.
Yes, my lord.
In other words, if a caste satisfies the requirement of social and economic backwardness,
Yes, ma'am.
then it becomes a class.
Yes, my lord.
Take any forward community.
Yes, my lord.
We'll not name the community.
Yes, my lord.
That community, can that be a class, a backward class for the purpose of 16.4? No. Why? Because it does not fulfill the parameters of backwardness. So if you see now, just read this a little carefully.
From President
Para 82.
82.
Yes, ma'am. Collating the aforesaid views.
Nevertheless, it may be stated that caste neither can be the sole criterion, nor can it be equated with class for the purpose of Article 16.4 for ascertaining the social and educational backwardness of any section or group of people, so as to bring them within the wider connotation of backward class. Nevertheless, caste in Hindu society becomes a dominant factor or primary criterion in determining the backwardness of a class of citizens. Unless, now this is very important.
Yes, my lord.
Unless caste satisfies the primary test of social backwardness as well as the educational and economic backwardness, which are the established, accepted criteria to identify backward class, a caste per se, without satisfying the agreed formulae generally, cannot fall within the meaning of backward class of citizens under Article 16.4, save in given exceptional circumstances, such as the caste itself being identifiable with the traditional occupation of the lower strata, indicating the social backwardness.
Yes, my lord.
Now, if we apply this test
Yes, my lord.
to the Balmikis
Yes,
and to the Mazhabi Sikhs,
Yes, my lord.
they clearly form a class. Because what our court is trying to say in this para, it's not a general assertion that, look, a caste can never be a class. They say, before you can come to the conclusion that a caste is a class, that caste must satisfy the yardsticks of backwardness, whether it is social, educational, or other types of backwardness.
There is a common.
In this case, it is no one's case that they don't satisfy the indicia of backwardness.
Yes, my lord.
In fact, your case is like them, you also satisfy the
Yeah.
indicia.
Yes, my lord.
So the fact we are dealing today, everybody who is before us
Yes, my lord.
satisfies the requirement, that indicia of backwardness.
Yes, my lord.
Because this is a battle between the backward and the backward. It's
Yes.
not a battle between the backward and the
Yes,
forward
yes,
in this
yes,
case.
Yes, my lord.
So all of you satisfy the requirement. That's why you're all inserted in the presidential list in the
Yes,
first
yes,
place.
my lord.
So it's necessary to understand what para 82
My lord,
means.
with
exactly,
respect,
no?
we have to test it from a different angle, my lord.
Yes.
Because we have to test it only from the angle of untouchability. Because the caste, suppose 37 castes are there, we are testing on Punjab.
Not really untouchability alone. It was not that, every one of our scheduled castes suffered from untouchability in its pristine form.
No, no, my lord.
There may have been many scheduled castes who did not suffer from the kind of untouchability that we associated with the social spectrum, but they nonetheless suffered discrimination. It may have been a form of untouchability.
My lord,
Social backwardness.
Social backwardness, social
that is,
ostracism,
my lord, Justice
not
Rama-
associating with them socially,
No,
being
Justice
confined to very
Ramaswamy has-
menial occupations.
Justice Ramaswamy has written a concurring judgment from state of Karnataka. So we can go to that, my lord. We will find, my lord.
इसमें और कुछ है?
95 देख.
जरा para 95 देख लीजिए जरा.
That's what is followed from my lord, the Chief Justice has said in so many words by Justice Jeevan Reddy.
By Justice
Jeevan Reddy.
Jeevan Reddy. Can
So many words. Just take para 782, 784.
Yes.
So many words that the caste is a backward class once it satisfies these tests.
Correct. Just see,
I'm-
Dr. John, since that has been read, let's clear it. But just
782 for a moment, Mullah, just kindly see that.
Okay.
778. 778 is exactly also on that one.
778. Mullah, I just read 3 lines. Mullah. Just come to 7.
Just 1 second, we'll go to it. And page?
Mullah, this is Mullah, in your PDF. And what you will find this, Mullah, at page 693.
My lord, may kindly peruse page 779, my
I
lord.
just read two paragraphs, that's all. Kindly come to Mullah's PDF 693, Placitum F. Placitum F, Mullahs. minutes. Placitum F, any authority entrusted with the task of identifying backward classes may well start with the castes. It can take caste A, apply the criteria of backwardness evolved by it, so to that caste and determine whether it qualifies as a backward class or not. If it does qualify, what emerges is a backward class for the purpose of 16.4. The concept of caste is not, in this behalf, is not confined to caste among Hindus. It extends so and so, so and so. Now let's come to para 784 on the next page. Again said even more clearly. Kindly come to 784. The next page.
Yes, yes.
The only basis for saying that caste should be excluded from consideration altogether while identifying backward class of citizens for the purpose of 16.4 is clause 2 of 16. This argument, however, overlooks and ignores the true purport of clause 2. It prohibits discrimination on any or all of the grounds mentioned therein. The significance of the word any cannot be minimized. Reservation is not being made under clause 4 in favor of a caste, but a backward class. Now, this is important. Once a caste satisfies the criteria of backwardness, it becomes a backward class for the purpose of 16.4. Even that, this is what is being submitted right now. This answers that. And then the pre-lunch debate, the next line, even that is not enough. It must be further be found that the backward class is not adequately represented in the service of the state. In such a situation, bar of 2 has no application whatsoever. Because not only
becomes a backward class of which sir.
So, Millards, to answer what fell from her ladyship, this is the clear answer. The caste, once it satisfies the requirements, Millards, given here, social educational backwardness is a backward class. That is why any.
It's clear, actually, very clear.
Absolutely clear, Millards. Absolutely clear.
Just one more para, Millards will permit. 778. That also puts it very tightly. 778. Indeed, there are very good reasons why the Constitution could not have used the expression caste or caste in Article 16.4 and why the word class was the natural choice in the context. The Constitution was meant for the entire country and for all time to come. Non-Hindu religions like Islam, Christianity, and Sikh did not recognize caste as such, though, as pointed out here and above, caste did exist even among these religions to a varying degree. Further, the Constitution is supposed to be a permanent document expected to last several centuries. It must surely have envisaged that in future many classes may spring up, answering the test of backwardness requiring the protection of Article 16.4. It therefore follows from the use of the word
2 and 784 are.
779 is also important.
Then one more thing, very interestingly, I just wanted to show you. I mean, we don't read it right now. In earlier part in the morning session, I gave that example of the aerospace. That is footnote 143 at page 690. Air India is
Yes, well, that's right.
What Articles 15.1 and 16.2 prohibit is that discrimination should not be made only and only on the ground of sex.
That's what 784 says, Millards. Here it is not just that, it is also inadequacy of representation. So the only 16.2 argument is specifically rejected on this ground, what fell from your lordship, Millards, in the pre-lunch session. Clearly.
Just all these para 766, note that 766, 771, 772 to 778, then 779, and then that's 779, that's it.
And 784.
And 82, 84, and 96, 97. 796, 97.
Complete.
I have it in a note, which I'll upload, which has all the quotations, so that it's easy for your lordship.
Just one comment. All these passages are only in the context of reservation for OBCs. Now, OBCs had to be justified at that stage, because Mandal was concerned not with scheduled castes, but with OBCs.
But Mr. Hegde, even within the OBCs, the point is that a single caste can become a class, provided. We see your point. You're saying, but no. In the case of SCs, because of Article 341,
yes,
it's the entire
thing altogether. I'll put it in.
Right.
I just didn't want the moment to.
Now we'll wrap up. We got the point. Let's Dr. Chauhan conclude.
Yes, ma'am. My lord,
Yes, Dr. Chauhan.
The next, my lord, issue is the theory of classification, my lord.
Yes,
How
sir.
you can classify, my lord. What Mandal has said about classification, my lord. Now, every often then, even in these proceedings.
So what is the submission, Dr. Chauhan, on classification?
My submission is, my lord, they are enabling provision only for the purpose of making classification, but it is not discretionary, because it is not discretionary for the state that they can allow some people the benefit and they can disallow some people that benefit, my lord. If a person is forming part of in a list, my lord, then they cannot discriminate, my lord. And this issue was considered by the 11 judges bench in Madhav Rao Scindia's case, my lord, and even Keswanand Bharti, my lord, 486 para, my lord. The Supreme Court has said that this is a controlled constitution, my lord.
Dr. Chauhan, you've made a point. We are going to put it to the other side. And simply put, your point is this, because this is a very valid point. That suppose the state, now in this case it's 2 castes. Some state says that, well, out of my 86, I'm identifying only 7.
Yes, my lord.
You leave out others
Yes, my lord.
who are similarly circumstanced. Can the state do that? Can they say that, look, I have, say, 25 castes which fulfill all the parameters of backwardness.
Yes, my lord.
Out of the 25, I'll only take 3.
Yes, my lord.
Normally, conceptually, an under-inclusive classification is a valid classification.
Yes, my lord.
The legislature does not have to deal with everybody to deal with someone. But I'm not sure that can apply over here. Because if there are a range of castes which are equally backward,
Yes, my lord.
can you then say I'll pick out only 2? But that again, that point is perhaps something we should leave when the challenge comes up before the High Court, you see, or before the 2-judge bench, whatever we...
With respect, my lord.
I'll give you another example.
Yes.
Suppose in this case, they had picked out only Balmikis
Yes, my lord.
and left out Mazhabi Sikhs.
Yes, my lord.
All right. Could the Mazhabi Sikhs not have argued that we are as backward as the Balmikis? Why have you left us? You are only taking the Balmikis. Or suppose they took up only the Mazhabi Sikhs.
Yes, my lord.
Can the Balmikis not have argued that, look, why are you taking up only the Mazhabi Sikhs? We are similarly situated.
Yes, yes, ma'am.
Which means, therefore, that those who are excluded can always challenge that classification under Article 14 on the ground.
Yes,
that, look, we are equally and we fulfill all the indicia of backwardness. But the state can also rebut it by saying that we can classify castes by looking at the extent of backwardness.
Yes.
We want to deal, as Brother Gawai said, we want to confer benefits on the most backward.
Yes, ma'am.
But while conferring benefits on the most backward, you can't ensure that some who are most backward, are only given while the others are left out. Otherwise, this will become a very dangerous trend in, popular appeasement.
Yes, yes.
Some state governments will pick out, a few castes. Another state government will pick out another set of castes. The idea is not to allow, popular politics to play out in granting reservations.
That's why Dr. Ambedkar has said that there should be no political
So
factors, ma'am.
even if we don't accept your wider submission, there is undoubtedly some substance in what you people are all pointing out to us, and we'll have to tailor it by laying down criteria.
Yes, madam. But my lord, may kindly peruse Madhav Rao Scindia judgment, my lord. 2 paragraph of that is 11 judges bench, my lord.
We have dealt with it in Article 370 recently. The article that is the privy purses, no?
Yes, my lord. Para 117 and 170, my lord.
What is the
my lord, they say that this is a power conferred on the president to identify, but suppose the president doesn't identify, then it will be unconstitutional. He cannot do it. He has a power which is vested, which has to be exercised.
Or power to do what?
To do.
Power coupled with duty principle, my lord. That
Do what?
Yeah.
Madhav Scindia concerned with the privy purchase.
My lord, kindly peruse that.
No, but it dealt with privy purses. It has nothing to do with Article 341.
My lord, that is there. From there we have taken that paragraph. 117 and 170, my lord. 2 paragraphs are there. One is by Justice Shah and another is by Justice Hegde, my lord.
Volume 5.
My lord, this is volume.
Where is it?
My lord, in the PDF volume.
Scindia doesn't deal with
वाला था ना वो, हाँ। Just a minute.
In Madras, India, what happened was
Yes, Madam.
that the rulers were de-recognized by an executive act.
Yes.
Though the constitution specifically recognized their status as rulers.
Yes, Madam.
Therefore, it was struck down on the ground that what the constitution had done by an express recognition, you could not undo by an executive order.
Yes, Madam.
Subsequently, they amended the constitution to abolish privy purses. That's why in the second round, before Justice L.M. Sharma,
Yes, Madam.
the abrogation of privy purses was upheld because it was a constitutional amendment.
That is only for the purpose of principle, my lord. That is for a different aspect. But the principle which was dealt by this honorable. My lord, this is in my sequence of submissions which we have given, my lord. And this is at page 108, my lord. The paragraph, my lord.
Okay. It's not there. It's on the screen actually. Okay. Sister, it's on the screen, not on the. So which para?
Para 117, my lord.
All right.
Could I go to page 109 in the top? There is a page 109, my lord.
Yeah, para 117.
117, it start in the earlier page, my lord. There are many analogous provisions in the constitution which confer upon the president a power coupled with duty. We may refer to two such provisions. The president has under Article 341, 342 to specify scheduled caste and scheduled tribe, and he has done so. Specification so made carries for the members of the scheduled caste and scheduled tribe certain special benefits.
Seats in the house.
Reservation seat in the House of People and in the State Legislative Assembly by Article 330 and 332, and of the numerous provisions made in Schedule 5 and Schedule 6. It may be noticed that scheduled caste and scheduled tribe are specially defined for the purposes of Article of the Constitution by Article 366 class 24 and 366 class 25. If
what they are saying is
yes, my lord,
that since the power to once the president makes a notification,
yes, my lord,
thereafter any deletion has to be by a law made by Parliament. The president can't just issue a notification and delete any entry.
Yes.
That's the point.
Well, now, my lord, because the principle which was settled in Indira Sani, my lord, in 9 judges bench, that this is a classification, my lord. Now, in Nagaraj, this honorable court has taken a view, this is a enabling provision and a discretionary remedy, which has led to scrapping of reservation in promotion almost all states, my lord. The interpretation should be as per the mandate of the Constitution, and my lord, whatever my lord have laid down in the larger benches, my lord. But still, that enabling provision and discretionary remedy was a part of Article Para 284 by Justice Thoman, my lord. He was a dissenting judge in that. Only he has used that phrase, which was adopted in Nagaraj, my lord. And this is a facet of that only, my lord, that we will provide reservation to one caste and we will not provide reservation to the other caste.
Alright, we got the point now. What's the next point, Dr. Chauhan?
Or para 788 of Indira Sani, my lord, that is at in volume 4A at page 693, my lord.
Page
693. 693. Paragraph 778.
No, but 788, my lord.
788.
My lord, it is at 693 page. My lord.
Yes.
Further, if one keeps in mind the context in which Article 16(4) was enacted, it would be clear that that assent was upon social backwardness. It goes without saying that the Indian context, social backwardness leads to educational backwardness, and both of them together leads to poverty, which in turn breeds and perpetuate the social and educational backwardness. They feed upon each other, constituting a vicious circle. It is a well-known fact that till independence, the administrative apparatus was manned almost exclusively by members of upper caste, Sudras and scheduled caste and scheduled tribes, and others. Similarly, backward class.
This paragraph is already read.
Yes, sir. No, this has not been read.
Yes, yes.
Yes, it has been read.
Last placetum H, my lord, we are accordingly of the opinion that the backwardness contemplated by Article 16.4 is mainly social
That has
backwardness.
already been read, Mr. Sodhil. Mr. Jawan.
What they held was the SCs and STs don't have to satisfy the test of social backwardness
Yes,
because
yes.
they are socially backward. That's
Yes,
what they
yes.
have said here.
Yes, yes, sir. And the connecting thread is only the untouchability, my lord.
So,
Because
is that all?
caste,
We got the point. We
which
made a
form
note
part
of that.
that group, my lord, in the list, my lord, they are basically, that is the main condition to enter into that caste.
Therefore, you can't bifurcate.
Yes, yes, ma'am. That's why
Thank you.
you
Thank
cannot
you,
buy.
Dr. John. Anything else now?
Just a minute, ma'am. Lord, in General Singh, my lord, para 23-24, my lord.
What are you relying upon that for?
Regarding that untouchability only, my lord, 2018 10 SCC 396, my lord,
volume
and
five.
this is, my lord, volume
PDF
volume 5,
It starts.
Page 908.
Which paragraph you are referring to?
my lord, 23-24, my lord.
935.
Simple, yeah.
Kalam, very small. Read it, my lord. This brings us to whether the judgment in Nagaraj needs to be revisited on the other ground that have been argued before us, insofar as the state having to show quantifiable data so far as backwardness of the class is concerned. We are afraid that we must reject Mr. Sri Shanti Bhushan's argument. The reference to class is to scheduled caste and scheduled tribe and their inadequacy of representation in public employment. It is clear, therefore, that Nagaraj has, in unmistakable terms, stated that the state has to collect quantifiable data showing backwardness of the scheduled caste and scheduled tribe. We are afraid that this portion of the judgment is directly contrary to the 9-judge bench in Indrasani 1. Jeevan Reddy J speaking for himself, then his para is extracted, my lord. The test of requirement of social and educational backwardness cannot be applied to scheduled caste and scheduled tribe, who indubitably fall within the expression backward class of citizens. Then Justice Thoman, though he was a dissenting judge, my lord, his para is also extracted. The only such class of citizen who are socially and educationally backward classes for the purposes of reservation under Article 15 and Article 16, their backwardness must have.
John, what this paragraph says is that for the SCs and STs,
yes, my lord,
the state need not collect quantifiable data on backwardness.
Yes,
because SCs and STs, by their very by the very nature, are treated as backward by their inclusion in the presidential list under Article 341. So to that extent, Nagaraj was overruled, saying that quantifiable data on backwardness, that principle does not apply to the SCs, STs.
So, in that way, my lord, in scheduled caste, once they form part of that list, my lord, then there cannot be a better scheduled caste or a worse scheduled caste or a privileged scheduled caste, because
you're right. That is the point all of you are making.
If a caste is attaining some better advantage, then the parliament is free to exclude that caste. Even a part of that caste can be excluded.
That's the point which has been made repeatedly.
Yes.
Thank you, Dr. Chauhan. I think we have to get along now to Mr. Rao and then Mr. Hegde.
I want to place only one important thing, my lord. Yes. There is a research article by Professor Owen M. Fish, my lord, and this para 163 is relevant, my lord. My lord, may kindly read.
Where do we get
only
that
one
article?
paragraph, my lord.
Where do we get the article?
This is like in our country. This is PDF page, my lord, 432, my lord, the volume which we have given.
Volume 5.
432.
Volume.
Court master is having that one.
Same volume. Volume 5.
No, but yes.
Okay. You can pass it in the evening, no problem.
Yes. Well, like in our country, my lord, in the USA also, my lord, for blacks, my lord, there is a campaign that rich blacks should not form part of that group. And to that he has answered this, my lord. Page 163, my lord. Moreover, second line I am reading, my lord. Moreover, wholly apart from consideration of administrative convenience, the decision not to exclude the rich black, even one identified.
It does not cite the US. You know the latest judgment of the US. They have said you cannot use race even as a factor in admissions. They have now gone the other way. So Justice Roberts
has
said that you cannot use race even as a factor in admissions. They never had quotas.
Yes, my lord.
But
their quota has come after our constitution.
No, they don't have quotas. But now even that has been outlawed by the US Supreme Court. So they are light years away from the position that we have evolved in our constitution.
No, but in their constitution there is no provision like our reservations, my lord.
As Mr. Hegde says that there's been a regression in that sense from our position in that sense in the US.
No, but in their jurisdiction or their jurisprudence, this reservation or relating provisions or relating principle was evolved because of Dr. Ambedkar, my lord. And since in our constitution this principle was adopted, that's why in 58 they have started adopting that. Our constitution came in 50, my lord. So much later they have adopted that principle, my lord.
They have never adopted quotas, and even now race as a factor has been rejected in the US.
No, because they do not have provision in their constitution, my lord. In our constitution, we have only.
Yes, Mr. Hegde, who wants to argue now? Thank you, Dr. Chauhan. Mr. Rao, yes. Thank you, Dr. Chauhan.
I'm obliged, my lord.
Thank you, Mr. Chauhan.
My lord, while deciding Chinnaya, my lord, there were 4 appeals, my lord, before the lordships, my lord. Lord, one was, my lord, appeal number 6759 of E.V. Chinnaya, my lord. In that, my lord, Mr. Chinnaya represented an organization. He is no more, my lord. But one of the members have there, my lord. Therefore, I am there also, but I must tell you, lordship, one thing. Yesterday, somebody mentioned, my lord, they are representing Chinnaya. Be whoever is representing, my lord, I don't mind. The point, it is the point which has to be canvassed.
Mr. Mishra said.
Then secondly, my lord, I appear, my lord, for.
You said that you are representing Chinnaya.
Yes, but Mr. Rao says Chinnaya is no more. Anyway, it doesn't matter.
No, I'll tell you, lordship.
The constitutional point, no difference.
But be that as it may, my lord, whoever does it, it hardly matters, my lord.
The
second party whom I am representing is, my lord, civil appeal number 6934.
Give that later. Tell us the point.
Yeah, the point, my lord, is this, my lord. While the legislature, while enacting laws, empowering the backward people, my lord, cannot tinker with the list, presidential list under Article 341, my lord.
That is the point which has already been made.
Therefore, I am not reporting that. Second thing, my lord, which I wanted to point out, my lord, one of the major questions before your lordship is whether Chinnaya requires reconsideration and whether the Chinnaya was wrong, my lord. My lord, we have to look at from the judgment of Chinnaya, my lord, from the point of view of what it was deciding, my lord.
Right.
The facts are very necessary. For that, my lord, kindly take the judgment, my lord. Chinnaya judgment, my lord.
Actually,
I will not.
The facts were read out to us.
The facts will not be narrated, but how the court has dealt with it.
Raju report and everything read out.
Since that's a major thing, I would like, I will beseech your lordship, I will not read the entire judgment. There are 4 or 5 paragraphs, which I want to show.
All right.
What were the questions before the court, my lord? Your lordship may kindly come to my lord. What were the questions? Page 800, my lord.
Of volume 5?
I'll give the equal. Yes, my lord, of volume 5, my lord.
Which para do you want us to read?
Para 55, my lord. But this is Justice Sinha, my lord. He dealt with the questions. What were the questions before the High Court, my lord? The questions before the High Court were whether the state's legislative power is curtailed or eclipsed by any provisions of the Constitution, whether the impugned act is beyond the legislative competence of the state and is violative of Article 341(2), whether the impugned act violates Article 14, 15, and 16, whether the impugned legislation is a colorable piece of legislation. Now, my lord, your lordship may kindly go back, my lord, to page 409, my lord, which is equivalent to, my lord, 789. Para 12, my lord. What was before this court, my lord?
Violative of, yes.
From the pleadings on record and arguments addressed, this is Justice Santosh Hegde, my lord. Whether the impugned act is violative of Article 341(2) of the Constitution.
See item 3, question 3.
Now, my lord, this is answered in para 26, my lord, after discussion everything. Then, my lord, whether the impugned enactment is constitutionally invalid for lack of legislative competence, para 31. Whether the impugned enactment creates subclassification or microclassification of scheduled castes so as to violate Article 14 of the Constitution, which is answered in para 37, my lord. My lord, I am not reading the reasoning, my lord, because it has been done and because my first proposition considers all that has been argued, my lord. But there is one thing which I want to point out, my lord. As the questions arose, my lord, what happens to the backwards who are below, who are not dealt with, my lord? For instance, my lord, in the state of Andhra Pradesh, what had happened, my lord? There were 59 castes, my lord. 59, 60, my lord, be that as it may. They were divided into 4, my lord, A, B, C. And class A, my lord, was given, my lord, comprising of 12 classes. Category A, comprising of 12 classes, were given 1%, my lord.
12 castes or classes?
12 classes, my lord. 12 castes, my lord.
Yes.
Then part B, my lord, category B, comprising of 18 castes, my lord, were given 7%, my lord. Then category C, containing 24 castes, my lord, were given 6%. Then category D.
24 castes.
Yes, 24, my lord.
6%.
Fourth is, my lord, 4 castes given 1%, my lord.
4 castes?
Yes, my lord. Now, my lord, what happens is, my lord, earlier, who were getting in the entirety in the 15, my lord, whether they could compete with it, did not do it, we are not concerned, my lord. But 15, I suppose I was eligible for the 15%, my lord. Today, by virtue of being classified into class D, I get only 1%, my lord. That is 24 castes will get 1%, my lord.
From 24 castes, you said 6%.
6%, my lord. But 50 from 24, my lord, 4 castes, 1%, my lord. 12 castes, 1%.
So earlier, everybody was competing for the entirety of the 15%.
Entirely. Earlier, I could compete for the entire 15%, my lord. Therefore, my lord, in the light of that, this judgment was delivered. That's why I read the questions, my lord. But what were the questions before this honorable court? Oh, my lord, what is actually happening is they have tinkered with 341, my lord, second portion. You have varied the list.
You have neither included nor excluded.
No, to say, my lord, that we are still there. No, but you have varied the list, my lord.
Still the same, they are all being given maybe different percentage of.
No, my lord, but today, my lord, what happens is, that's why I said, my lord, 12 people, 12 castes or 4 castes.
There could be other reasons also. What is their population? What is their population ratio? What is their representation in the services? That is an exercise to be undertaken by the government.
My lord, that the earlier advocates have shown, my lord, that there is a route to it. If you find somebody has gone above the threshold, my lord, delete them. If you want to bring in new people,
and do it. They can't do that. That is done by the central government.
list, my lord.
But they are trying to maintain a balance between all the castes.
It's a different matter that for arriving at such a finding, there was no empirical data.
There was nothing.
So that will be going to the merits of the matter.
So therefore,
Whether it is permissible or not, that's a question.
whether as a matter of principle, Chinnaiya is right or wrong, we are deciding. But the Act may still not pass muster in the absence of verifiable data in regard to underrepresentation, etc.
Well, this is 2005. Then 7, my lord.
Initially, my lord, the ordinance was challenged, which was upheld, which was struck down. Then the state came here. Then the legislation came.
Ask us the other side. Anybody dealing with Andhra Pradesh on this side or?
No, nobody. Mr. Luthra made a statement that we will abide by the judgment, my lord, as if they have a choice.
Dr. Muralidhar appeared for Andhra Pradesh, and they said
they will abide by it, my lord. As if they have a choice. Whatever your lordship say will be.
Chinnaiya set aside the act. All right. So Chinnaiya held the act to be unconstitutional.
Right, my lord.
Now, if we in a separate proceeding, if we come to the conclusion that the judgment in Chinnaiya does not lay down the correct principle, that will not per se result in the validation of the act. Because we do not have, because, one second, we do not have any appeal pertaining to Andhra Pradesh before us, right?
There is a writ now, my lord, filed by some of the people who get benefit by this, my lord. For I think Mr. Venugopal argued.
My lord, I appear for the state of Andhra Pradesh. My lord, the Chief Justice has rightly observed there is nothing by way of an Andhra Pradesh review pending as far as this reference is concerned. So
how is Andhra Pradesh before us? How are the people from Andhra Pradesh? They are interveners or what is
yes,
that?
No, my lord. Actually, by way of a PIL, that is in item 701.22.
Yes, Mr. Krishnan.
My lord, in item 701.22, a writ petition has been filed arraying all the states of the country asking for overruling of Chinnaiya. That is the only incidental basis on which Andhra Pradesh is technically before my lords.
In a collateral proceeding, even if we overrule Chinnaiya,
that's right.
That will have no impact on the act which has been.
Yes, that act has been struck down, my lord, and since the act has been struck down in our own case, we have not reenacted anything in defiance of this honorable court's judgment.
It's open for the state if they want to come with a fresh enactment or not.
Yes.
And only after a fresh enactment comes in the eventuality.
And that will be and that be subject to a challenge.
Why I am not going that far is, my lord, I don't want to come back again saying, my lord, that in view of your lordship they have reenacted. Today, my lord, this was actually a political move, my lord.
But Mr. Rao, we will not comment on the facts of the Andhra Pradesh Act in this proceeding, for the reason that whatever we do is not going to affect the mandamus or the certiorari which was issued by this court, or the declaration which was issued by this court in Chinnaiya, which was there inter partes. What we will decide here, the only live case which is before us is the Punjab case.
But
furthermore, if I may just say this,
a series of litigations would start, my lord. The enactment should come, my lord, because this move in the state was only for a political purpose.
Yes, वो एक मिनट बंद कर दो.
Yes, yes, sir, it's not only money, it's not only lawyers' money.
Petitioner, who is the lead petitioner, was the lead petitioner and petitioner. And then matter traveled here, it was registered on the name of EC Chinmaya. I was the second or third petitioner there, separate petition that my name is there. I am there, Milad, from the Andhra Pradesh side to represent the scheduled caste. And Milad, here I will just deliver upon whether the backward classes that and the 16th class 4 includes scheduled caste or not.
That is the only preview of my argument. So, Mr. Rao, what else now?
The problems which were raised by the court, my lord, as to what happens within the group who are not then. Lord Justice Sinha has given certain remedies, my lord, which are at page, my lord, for 815, my lord. Apart from that, my lord, a solution can be found out as to how, my lord, these things, reservations have to be worked out, my lord. Yes, my lord, we are seeing, my lord, because of the ground situation, that some people are garnering, my lord, some people are not getting it. They are not getting it because of the socio-political situation that they are not allowed in the village, and the census is taken only in the village, my lord. This has to be restricted, my lord. Maybe one suggestion is, my lord, which suggestion I am giving as an officer of the court, my lord, not this thing. But suppose, my lord, what happens today is, my lord, a person is getting a reservation.
Suppose a person is getting reservation, my lord. He gets reservation at all stages, my lord. For instance, at the admission, at the time of school, at the time of college. For instance, he goes into a medical this thing, my lord, he gets the reservation. Then in the job, he gets the reservation. This has to be looked into by the government, my lord, how as to see, my lord, that how it reaches to the bottom. But it can't be, my lord, that they will tinker with the list, my lord.
They are not tinkering with the list.
No, they have varied the list, my lord. From 15, I got one, my lord.
It's not a varying the list. Where is it provided in the list?
The list never gives you 50%.
The list never gives you a percentage that you will be getting 50% or somebody is getting
20%. Today, my lord, the constitution, in the constitution it is provided that SC/ST would get how much they will get, my lord. That has been varied, my lord.
Nowhere it is provided in the constitution.
Where does the constitution say that you get 15.5% reservation? Show us the provision.
Adequate representation.
Huh?
Adequate representation.
Adequate representation.
But I am today, my lord, I have been deprived of it.
But therefore,
my percentage has gone down, my lord.
But therefore, your argument is on the challenge to the act per se, not on that doesn't turn on Chinmaya.
Act per se, my lord.
That act is nowhere in existence now. So
Act is not, but since we were parties in the original, my lord, and that judgment is under reconsideration.
Whatever happens, the judgment that can't result in a revival of the act.
That's it.
All right, thank you, Mr.
Can I get a small written submission, my lord? Yes. Lord, I also appear in one of the IAs, my lord, filed by a police officer. That IA number is, my lord, 120962 of 2020. I'll give it to the court master, my lord, the matters in which I am appearing.
Yes, Mr. Hegde.
Not the others I am not repeating, my lord, I wanted to show them.
What is the point that you want to make?
Just a bit. I do realize that we are at the end of a long and weary hearing. So therefore, I will not bore your lordships. I'll go on the sound principle that if you don't make a point, you stop boring. Now here, my lords, it's like this. The point that Dr. Chauhan finally came to was what is the distinction
that marks a scheduled caste? And the answer given was untouchability. I want to bring to your lordship's notice a judgment in Suicide, which sets it out succinctly, and our constitutional history. It is 1985 Supplement SCC, page 590, my lords, paragraph 7 thereof. It has been uploaded. Please, my lord. Para 7. Now, it cannot be disputed that this caste system is a feature of the Hindu social structure. It's a social phenomenon peculiar to Hindu society. The division of the Hindu social order by reference at one time to professional or vocational occupation was molded into a structural hierarchy which over centuries crystallized into a stratification where the place of the individual was determined by birth. My lords, after all that preliminary thing, my lords, let me just come to the second part of J.H. Hutton, the last line of 594. J.H. Hutton, a census commissioner, framed a list of the depressed classes systematically, and that list was made the basis of an order promulgated by the British government of India, called the Government Scheduled Castes Order. The Constitution Scheduled Castes Order is substantial.
That we saw yesterday, actually.
Please, my lords. Now, during the framing of the Constitution, the Constituent Assembly recognized that scheduled castes were a backward section of the Hindu community who were handicapped by the practice of untouchability. And this evil practice of untouchability was not recognized by any other religion. And the question of any scheduled caste belonging to a religion other than Hinduism therefore did not arise. The Sikhs, however, demanded that some of their backward sections, the Mazhabis, the Ramdasyas, the Kabirpanthis, and the Sikligars, should be included in the list of scheduled castes. This demand was accepted on the fact that these sects were originally scheduled caste Hindus who had only recently converted to the Sikh faith and had the same disabilities as the Hindu scheduled caste. The depressed classes within the fold of Hindu society were therefore made the subject of the original Constitution Scheduled Castes Order, subsequently was also amended. Now, my lords, the point is this. The difference between the three categories. Scheduled castes necessarily means that everybody has suffered the taint of untouchability. How untouchable? That's a different thing. There were some people who were merely not seeable. There were some people who were touchable. There were some people whose money could be touched. Now, all of those were put into one class by the Constitution of India, in the constitutional order, in the presidential order. And that is why they were called scheduled castes. Now, the castes may be individual.
From where do you find this?
My lady, I just read this.
Yeah.
I read this passage.
In the judgment.
In the judgment. And my lords, there is supporting material also that can be placed. But, there are several judgments of this court which go on the footing that what distinguishes the scheduled castes from the other backward castes is the taint of untouchability. Once there is the taint of untouchability, how untouchable were you? The Constitution and the Constitution makers at that point of time decided not to go into that question. They formed one homogeneous class. And that homogeneous class they said that you could possibly include or exclude through parliamentary enactment, but in no other manner. So therefore, a court could not add or subtract from it. The executive could not add or subtract, nor can the state legislature tinker with it in any manner whatsoever. That, my lords, is the basis of Chinnaya. And the passages at paragraph 26
That we have seen.
onwards, that was the basis. Now the basis that 341(2) stood as a barrier to anybody else tinkering is supported not only by the speech of Dr. Ambedkar,
but it is also supported by another constitution bench, which is a 5-judge bench, which is Bir Singh. Devender Pal refers to Bir Singh but does not appreciate Bir Singh, my lords. Bir Singh, just get it on the board, 2018 10 SCC.
Please, my lords. Yes. If your lordship first sees the question which was posed, the question in Bir Singh.
Page.
Yes. I'm sorry.
Citation page 312.
312, but my lords, to cut short time, the question in Bir Singh was basically whether if somebody was a scheduled caste in one state, but then migrated to a union territory, would he have the scheduled caste status? And in that context, my lords, if I can place paragraph 36 onwards. After noticing these various questions, please, my lords.
I think Justice Bhanumati dissented, right, there?
No, there's a slight dissent, but not on in this. Please.
Para 36.
Para 36. The upshot of the aforesaid discussion would lead us to the conclusion that the presidential orders issued under Article 341 in regard to scheduled castes and under Article 342 in regard to scheduled tribes cannot be varied or altered by any authority, including the court. It is Parliament alone which has...
More than settled.
Yes.
Not tinkering is more than settled right from action committee.
Please, my lords. Now, if please,
is the state tinkering with the list? Are they
yes,
reviewing any entry or adding any
please,
entry?
my lords. If I'm sorry, my lords.
It is not under our control. It is somebody else is managing there. We were trying to go scroll down and scroll up.
Yes, my lords. So 36 to 38.
You are under our control, no problem.
It goes on the same footing. Now the
quarrel on that proposition that no tinkering is permissible by any authority in the court.
Now let's take this further. If I continue to be a scheduled caste in the list in name only, but no benefits are conferred on me, while benefits are conferred on another scheduled caste in that same list, I am effectively rendered with the stigma of a scheduled caste, but no consequent benefits. That can also happen. In a sense, it's a reverse pran pratishtha. That my caste remains on the list. And yes, you are a Jatav or but for this year, we are taking only Valmikis. Or to use the Maharashtra example, if we say that no Mahars will be taken.
Right, but therefore, this is a challenge not to subgrouping in principle, but the manner in which the subgrouping has been carried out.
It's also,
for instance, that's why I give them the example. Suppose Punjab had said we are taking only the Balmikis and not the Mazhabis, or only the Mazhabis and not the Balmikis. Would that not be amenable to challenge? Possibly, yes.
That would be tinkering, my lords, in my respectful
Right,
submission.
consider that.
In my respectful
Now,
submission.
we've heard that
No,
for the...
yeah, just 1 minute. Just 1
Nothing
minute.
new now.
Let me give your lordships an example.
Same is the common refrain now.
Let me just.
We were keen to now put some points.
You
Yes,
you had assured us that you will not repeat anything, but you are repeating the same thing, right? From Mr. Swarup and everybody else.
Please, my lords, one last.
Yes, tell us.
One last reason why your lordships should not leave it to the states. Your lordships noticed Dr. Ambedkar's thing that political ones.
Political.
Now, Now, my lords, India is not comprised only of big states like Punjab, Andhra Pradesh, or anything. There are a lot of small states. And a political decision there. For instance, your lordships have seen the recent violence in Manipur. Now, if only one particular community is knocked out, if you leave the power to the hands of individual states without any reference back to the center, my lords, then what we are asking for is effectively a balkanization of this list. You would be setting up one, as you are, borrow the Chief Justice's language, backward against backward.
All right, thank you. You got that. Thank you, Mr. Now we're going to, yes, Mr. Meshram, we'll give you 2 minutes, please. Yes, what is the point just formulated, Mr. Meshram?
Yes. That 16 class 4, which talks about backward class of citizens, Millard, that does not include scheduled caste, Millard. I am aware about the Indira Sawhney judgment.
What is your submission?
Yes, Millard. When the backward classes was included, backward word was included in Article 16. Millard. Before that, the scheduled caste reservation was already settled in the Constituent Assembly. And therefore, the reservation.
That backward classes doesn't include scheduled caste?
No, sir. No, Millard. Therefore, I will take my lords to the Constituent Assembly debates, Millard, and the PCUR's documents, Millard. And this argument has never been taken.
But that has been dealt with in
yes,
yes. A larger bench.
No, Millard, this is how nobody nowhere in the history of the Supreme Court, Millard, that argument was built upon by this court, Millard. And therefore, Millard, straight away I'll take to this court on the minority subcommittee's report, Millard, of 1947, my volume 4D, Millard, compilation, filed volume 4D, Millard.
For ABC, B.
For D for Delhi, Millard.
We don't have.
For D to Delhi, there is no D.
For B, you said, no?
We have sent the email. Yesterday we have sent the email.
A, B, C, D. You have to send the email to the nodal council because then only nodal council are authorized to add to our report.
The nodal councils, Millard. But I'll just read it out to Millard for that purpose. I'll read it out to the Millard. That the subcommittee then, this is from the B. Shiva Rao. This is the minority subcommittee report. The subcommittee then examined the demand put forward by representatives of Anglo-Indian community, but thought it advisable that the question of both minorities reservation in services. The subcommittee voted on the general proposition that there shall be reservation in the public services for the different communities mentioned in Group A, B, and C of paragraph 3, clause 3, Millard. Millard, paragraph 3, clause 3 pertains to Anglo-Indians, that is Group A. Group A, Anglo-Indian, Parsis, Plains tribesmen in Assam, Millard. Group B pertains to Indian Christians and Sikhs. And population and Group C, Millard, for the Muslims and scheduled caste. So now, Millard, they were considering the reservation for these 3 groups, Millard, and they have held, it was agreed that the provisions, if any, regarding reservation, word is most important, Millard, regarding reservation should appear in a schedule up to the Commission Act, Constitution Act, and should have the force of directive of government policy. The decisions were as follows. 1. Agreed by a majority of votes 16-1 that there shall be reservation in the services for the scheduled caste. This is Article 296, Millard, corresponding to Article 335 of the Constitution present in Millard. Then agreed by a majority of votes 9-7 that there shall be reservation in the services for Muslims, and so on and so forth, Millard. And then they have specifically considered one more aspect, Millard. that the submission that the subcommittee then considered the question as to whether seats should be reserved even for post which computation examinations are held. The decisions were as follows. A, agreed by a majority of votes 11-6 that there shall be reservation for scheduled castes in services to which recruitment was made by competitive examination. This is Article 296 corresponding to 335. Now, Millard, that 296 was differently worded during that time because the reservation was granted based upon the minorities, Millard. And that article, Millard, was worded as.
What is the submission that you
Submission is that the 16 class 4 does not apply to the scheduled caste and their reservation comes from 335. Because altogether this aspect was
335.
335.
335 doesn't speak about reservation. It only says that
yes, Millard.
claims of the scheduled caste will be taken.
To the efficiency of administration. And the danger of making that argument would be that it ceased to be a part of the chapter on fundamental rights.
Yes, Millard. That's what we are just explaining, Millard, that what transpired in the Constant Assembly. This is what I'm exactly proposing, Millard.
Mr. Meshram, you are appearing for which matter?
Millard, this is the implement application I have filed
the
for the
Punjab
state
matter.
of Andhra Pradesh.
State of Andhra Pradesh.
No, Millard, not for the state of Andhra Pradesh. The one person who was the petitioner in Andhra Pradesh matter in 2019.
You are one of the petitioners.
And in the Supreme Court also, I was a petitioner in Chinnaya, Millard.
All right.
And therefore, Millard, we have won that case in Chinnaya, Millard. So therefore,
You are saying reservation for the SCs doesn't come under 16.4 at all.
that is historical truth, Millard. That is a historical truth, Millard. And therefore, 296 was worded, Millard.
But then why did the Constitution, what was the Constitution amended to include clause 4A?
That was because,
4B.
Millard,
And then why was the Constitution amended for the first time in 1951 to bring sub-article 4 in Article 15?
Millard, 16 class 4 is the original article.
No, 16.4.
Yes.
Then if your argument is to be accepted,
yes,
then the reservation in educational institution would also go away.
Millard, that was Article 15 class violation or class 1 of 15 class violation, Millard. And that was for the backward classes, Millard, not for the scheduled caste, Millard.
No. The GO of Madras government was specifically for scheduled caste, which provided 10% reservation.
Communal reservation.
Communal, and they said, Millard, in Champakam, that is hit by the discrimination based upon caste, Millard. So therefore, that has come, Millard. But let us appreciate the fact, Millard, this is historical.
No, but then what happens to the entire law which has come from N.M. Thomas onwards, that
Yes, but those judgments
reservation in favor of scheduled caste, scheduled tribe are traceable to 16.4.
I thought these are all flag bearers of the movement for the status to the scheduled caste. If we have to today say that N.M. Thomas and Akhil Bharat Ke Shoshitan, they all will be overruled.
Millard, due respect, with due
We'll be
respect,
going
they have
back
not
to
considered this.
we'll be going back to the Devdas and the Devdas days.
Millard, neither Indra Sahani, Millard, or the judgments which were rendered before that, Millard, they have dealt with this. Even Millard, the Champakam did not deal with this, Millard. And therefore, Millard, 296 was worded, Millard, that very technical.
Let me consider it. You have filed your written submissions, right?
No, Millard.
Then give us a
Millard,
short note,
let us
put
see
it on
the
the-
article
16 class 3, Millard. That 16 class means the 10 class 3, Millard. Present day 16 class 4, Millard. There is a debate on this, Millard, in the Constant Assembly, and whether the backward classes
It can't be confined only to a Constituent Assembly debate. Now
Yes.
we have a rich body of jurisprudence on 16.4.
Millard,
We can't say that the
Millard,
scheduled
we-
castes are not within 16.4. This will be extremely deleterious
we
to the movement for justice to the scheduled castes if we even accept this argument.
Millard,
How
if
can we even
we cannot reverse the truth in this court.
Very
We cannot reverse the truth, Millard.
Very
We cannot
erudite
reverse
judges
the
before us
Constant
have
Assembly.
gone and decided this whole body of law. We are really just pushing the baton, that's all. We don't want to reconsider this law which has been laid down with such great vision
Absolutely,
and
Millard, but we cannot reverse the truth
passion
while
for
speaking
social
in this
justice.
court, Millard. This is the truth that Article 335 was inserted in the Constitution, means that the discussion took place much before. Milad, much before Article 16 Class 4 came into effect, Milad. Even Milad, the first constitution that is settled by the advisors of the Constituent Assembly, Milad, that includes Article 335, Milad, but that did not include Article 16 Class 4, Milad, in the present form. Milad, first, second.
All right, thank you. We'll give a little time to them now for the rejoinder. Yes, Mr.
Milad.
One second. Now all things good have to come to an end. Anybody wants to make 1 second? Anybody wants to make any submission? Please put it down in one page on a piece of paper. We'll consider it.
Milad,
we have to now.
I will circulate a submission, Milad.
Sure, sure, yes.
I believe your lordship had called for the council for Telangana or Andhra Pradesh.
No.
My lords, may I?
We just were on this.
Mr. Rao, consider you to be Dr. Muralidharan.
Actually, the state of Tamil Nadu case is slightly different.
Either that, someone laughed at this amendment.
Mr. Champaglaji, you're going to be very heavy a submission for us. We will give you a minute or so at the end of it after we hear.
No, he doesn't want to argue. He wants
you want to hand over something. You don't want to argue.
Yes.
Want to
hand over
something.
My ID is on board.
Yes.
My address is on board.
It's already on board.
It says 9354920.
All right.
May I make a request?
No, now,
with
sorry,
regard to Tamil Nadu.
yeah.
With regard to Tamil Nadu. Tamil Nadu has never been touched upon by anybody.
Who are you appearing for?
I am appearing for 17.3 for a private party who has challenged the act also for an impleading petitioner in 17.1.
Right, but therefore we are not going to deal with the validity of the act here.
I'm not.
We will be restoring. Yours is a transferred petition, right? Transferred writ petition.
No. This is a writ petition.
Who has filed a writ petition?
Transferred petition, but the point it was.
Oh, I see.
They have filed a substantive petition.
Writ petition here.
Substantive petition we have filed.
Who is the petitioner counsel in that case?
I am the petitioner counsel. The local council could not be here. I will just take your lordship.
What is your contention?
Two aspects, Lord. With regard to E.V. Chinnaya's case, para 85, I will just take your lordship to.
Just formulate it.
Lord, that cannot be a class. Lordship was consistently saying that there can be a class. Lord, there cannot be a class within a class. Lord, actually they themselves a class. And what happens
is there cannot be a class within a class.
There cannot be a class within a class because the entire people is themselves a class. The lordship will see how.
That's what Lokinath Sota said, and which Chinnaya relies upon. There can't be a micro classification.
Lord, that is what I'm just trying to say in a different format. Because what happens here in Tamil Nadu is, Lord, your lordship will see there are 7 castes out of 76, Lord. 7 castes out of 76, Lord. Namely, Arundhatiya, Chakliyar,
Madari, Madiga, Padagai.
Right, we can name them. We've seen the name.
Not this 7 class. This 7 class has been classified as Arundhatiya and have been given out already for the past 15 years. They are being given
3% in priority. They will be the first person to be considered in the SC list. As my learned senior Hegde told, there will not be any chance.
3% out of how many?
Out of 18, if there is only 1% in a post, assuming for a minute, if there is only 1 post for a minute
for a solitary post, there
is no reservation.
No. If there is 1 post for SC, I'm just trying to say, if there is 1 post for SC, that will be given only for SCA. That is SC Arundhatiya. And they will not be, it will be carried for next 2-3 years. Even assuming if that is not.
You're not considering the validity of the act at all here.
That's why I just wanted to read.
We may not address that matter at all on merit.
I just wanted to read this.
Liberty to file a petition for the High Court under 226.
If your lordship permit me to read 85 for a minute.
As the constitution itself treats the member of the scheduled caste as a single integrated class of the most backward citizens. It is not competent for the legislation of a state to subdivide them into a separate compartment with a separate percentage of.
That has already been read to us so many times.
So many
Lord,
times now.
that is what, my lord, actually, I'm just trying to bring before your lordship is
Out of 76. We don't mind listening to you, provided you make a good point.
No, that's what.
Today is now we are 15 minutes short of concluding the hearings. Tomorrow is miscellaneous.
Hold on. That is what I'm just trying to say. Out of 76, they have formulated a 7 as a subclass.
But that's what we told you. We are not going into the validity of the act here. We can't go into the validity of the act absent a proper contest. We'll
I am appearing for some petition raised against Union of India. In that case, my lord, Constitution Scheduled Caste Amendment Act 2021 enacted.
Appearing for, sir?
Well, I am appearing for 701/10 petition.
That's all right, but we are not going to answer, validity of each individual act here. This is a challenge to the validity, the correctness of Chinnaya is what is in question before us.
That will have a direct bearing on it. That will have a direct bearing on it.
Sorry?
Lord, so far Tamil Nadu petitions are concerned, my lord, my learned friends are arguing the writ petitions, my lord. Those petitions were sought to be transferred here and lordship has heard this matter.
So we will send them back.
Yes.
We'll send them back to the High Court.
Yes, my lord. That's what we have said.
Yes, we'll have to send you back to the High Court.
The Scheduled Caste Amendment Act actually passed by the similarly placed communities in the same caste, 7 caste for Arundhati by Tamil Nadu Assembly, another 7 caste Devendra Godavar by the Parliament, my lord. Itself shows that the state government has no power, my lord. That's my
I'd like to appear for an intervener. My lords, I have already placed my written submission.
Please consider the written
But my lords, there is only one submission that I wish to bring to your lordship's notice. Just 1 minute on that. My lords, I wish to submit that the list which is there under 341 is not merely a list of identification. With great respect, my lords, the term that they will be deemed to be scheduled caste for the purposes of the constitution, my lords, is actually a conferment of an identity, which, my lords, has been conferred through the mechanism of a precedential order. Once that happens, my lords, all rights, privileges, etc., that are flowing under the constitution would be available to them as a class.
Absolutely, no difficulty. Correct.
It's a constitutional class.
That's the argument which everybody has made on this side.
Well, only one aspect, my lords, I'm trying to pitch it a little higher than the mere fact that it's a list of identification, and that this can be then bifurcated. My lords,
They're emphasizing for the purposes of the constitution. So every benefit which inures to the ST.
Then everything applies to them en masse, my lords, equally. It can't be, my lords, that a particular, because they lose, my lords, with great respect, they lose their independent, distinct, my lords, identity. They become identified as my lords, entity under 341. My lords, that's the submission I made in that written submissions.
Yes.
My lords,
Yes, Mr. Advocate. Yes, Mr. Advocate General. Thank you.
Grateful, man. My lord, just 2 things which have been brought up by the other side in the arguments. I'll briefly touch, my lord. Your lordships have heard a lot on these issues. My lord, first, of course, is, my lord, that it is a homogeneous class because they are all born together, my lord, which factually and legally would be incorrect. Because the inclusion in the first order in 1950 may be a contemporaneous birth, my lord, but subsequently the addition deletion by the parliament ensures that any other caste can be brought onto the list under 341 at a different time. So most certainly, my lord, being born in the list together will not give them a homogeneity which the other side seeks to plead, my lord. I'm just cutting it very short, my lord. Now, my lord, the issue is, my lord, then regarding, my lord, the presence of the word tribal in both 341 and 342, my lord. And your lordships had correctly pointed out, my lord, though I noted it on that time, that some castes may have people who belong to a tribe and some may be non-tribal scheduled castes. So therefore, my lord, both have been included and whatever is relevant and whichever defines the caste more can be brought into play, my lord. That is my short submission. Your lordship may have already given the gist of it during the rebuttal, my lord, to them. Then, my lord, the status of word deemed, my lord. Now, my lord, I had again thought of it last night, my lord. In my submission, the word deemed is very clear because, as your lordships pointed out, that by mere inclusion in the list,
your caste birthmark does not get obliterated. And there is a possibility that tomorrow you may be excluded from the list. So therefore your caste, which is by birth, will never change. But your deemed status of a scheduled caste for the purposes of benefits under the constitution can change.
So you cannot permanently designate somebody as a scheduled caste under the constitution. That is my humble submission. The status of scheduled caste under the constitution is not permanent. And as long as that caste exists on the list under 341, a deemed status gets attached to it, which can be removed the moment the caste is out. That is what at least I could, my lord, gather in my research, my lord.
Then, my lord, an issue which has engaged your lordships is regarding class and caste, my lord. The question had fallen from your lordships, my lord. The paragraphs, my lord, from Indira Sahni, my lord, which have been read, my lord, there's no need to repeat them. Your lordships have extensively looked into it. Now, there are those other paragraphs, my lord, in Indira Sahni.
But the argument is that Indira Sahni, a caste, they say could be a class in the context of the socially and educationally backward classes.
That's right, my lord.
So that if a particular caste satisfies the indicia of social backwardness,
that's right,
it can become a socially and educationally backward class.
Quite right.
Argument is that this will not hold true, or this will hold true
with a difference in the case of the scheduled caste, because a scheduled caste does not have to satisfy the indicia of social backwardness.
Quite right.
Any caste, once it is designated as a scheduled caste, is presumed to have the indicia of social backwardness, because there's a pre-existing inquiry which takes place.
That's right.
Therefore, they said that, look, unlike the backward classes, the entirety of the grouping of scheduled castes is one homogeneous group. That is the argument.
That is their argument, my lord. But what your lordships have seen, my lord, that a class is not necessarily defined by a caste. A backward class of people may have to be identified with strong reference to their caste, but merely possessing a caste will not classify them as backward. On the reverse, my lord, a scheduled caste, there is a presumption of backwardness already.
So but therefore, the scheduled castes are a class.
My lord, yes. Scheduled
but
castes are a class.
Is an individual scheduled caste can be equated with a caste, with a class?
Yes. So therefore, the ingredients of backwardness would have to be satisfied still. The relative backwardness, which we are urging under 16.4. That's right.
You do not have to satisfy the indicia of backwardness at all.
Only for the purposes of most backward within the backward.
No, but before we reach that question,
that's right.
The argument really is that once you're a scheduled caste, you are presumed to satisfy the indicia of backwardness.
That's right.
Therefore, the entirety of the grouping of scheduled castes constitutes one class.
Please,
and how can there be a class within a class, therefore?
No, that
is the argument.
That is the argument. But what we are dealing with, my lord, in the present matter, is a class within a class only. As your lordships have said it, it is forward backward versus backward backward. Let us take it like that, my lord.
I'm not sure whether, a class within a class is what 16.4 permits.
Lord, that's what I'll just come to in half a minute. Lord, now, as long as the ingredients of quantifiable data of non-representation in the services is met, the state can make a special provision of reservation for that particular class.
Provided it is a class.
Provided it is a class. So therefore, the creation of a class.
And how can you then create one caste as a class?
Not caste as a class, my lord. Not caste as a class. The criteria would only be backwardness. Therefore, I'm saying under 16.4, unlike 15.4.
But every entry in the presidential list satisfies the indicia of backwardness.
That's true.
So there is no question of then saying that it becomes a class because it satisfies the indicia of backwardness. Everybody has the indicia of backwardness, and therefore everybody is together, bunched together as a class.
Quite right, my lord. Lord, if we read 15.4 and 16.4, Lord, just before I come to that, I've given Lord 5D, Lord, volume. Your lordship may only refer to 3 judgments, Lord. 2 of the vintage of 1960s and the other is of 1994, Lord. I'll just read the two paragraphs I want to refer to, my lord. 5D, if your lordships can kindly have a look, my lord. First judgment is, my lord, Action Committee on issue of caste certificate versus Union, 94-5 SEC 244. Kindly have para 3, my lord, of this judgment. I'll give the paragraphs, my lord. They can be read. That is on 341, so therefore I'm not dwelling much on it.
What is the citation of Action Committee?
Action Committee citation is, my lord, 1994, volume 5, SCC page 244, my lord.
At para 33, at para 3.
Para 3 and para 16, my lord.
Let's see that. No, there's nothing here really.
No, this is only regarding the power of the parliament. Therefore, my lord.
Para 16?
Para 16 is, my lord, we may add considerations for specifying a particular caste or tribe or class for inclusion in the list of scheduled castes